Figure it out. So we're live right now.
Hey, Case, can you hear me? Because I can't hear you at all.
I know. Hey, we're live right now, by the way.
Oh, we are? Okay.
Hello, everyone, and thank you for joining us with NOCAP Sports Moot Court Madness. First, I'm going to start off by introducing our judges. Thank you so much for joining us today. Maddie Salomon, Michelle Gervais, and Jeremy Evans. A little bit of background on everyone that is judging. Jeremy is the Chief Entrepreneur Officer and founder and managing attorney at California Sports Lawyer, representing entertainment, media, and sports clientele. Evans is an award-winning attorney and industry leader based in Los Angeles with clients ranging from Fortune 500 companies to entrepreneurs, athletes, entertainers, models, directors, and more. He specializes in contractual, intellectual property formation, production, distribution, negotiation, and deal-making matters. Prior to opening California Sports Lawyer, Evans worked as a graduate law clerk at the Superior Court of California, advising judicial officers in civil and criminal law and motion matters. Thank you for being here, Jeremy. Great. And Maddie Salomon is an attorney, college athlete advocate, and former scholarship lacrosse player for Duke University. During college, Maddie served on and eventually chaired the NCAA Division I Student Athlete Advisory Committee, also known as SAC. In that role, she served on rules working groups and legislative and leadership councils within the NCAA. She also successfully advocated for college athletes to be granted voting power in the new governance structure and was awarded the ACC President's Award for Exemplary Service in 2017 for the lasting impact of that advocacy. Maddie has been a leading voice for NCAA reform and college athletes' rights, working with leaders across the country and publicly presenting on the major issues in college sports, including name, image, and likeness. We are very excited to have Maddie with us as a judge for today's hearing. Michelle Gervais advises high-profile athletes, celebrities, and executives, as well as businesses in the sports, entertainment, and finance industries in complex disputes that involve the intersection of business and family law matters. Known as a fixer across several legal disciplines, Michelle handles highly delicate matters, protecting her clients from serious financial and reputational harm. For select professional athletes and executives, Michelle helps them handle a variety of family law matters, including dissolutions of marriage, domestic violence, paternity, custody support, and prenuptial, postnuptial, and cohabitation agreements. She also assists her clients and their businesses with other risk management issues affecting their brand, their company, and their professional legacy. Thank you, Michelle, for sharing your expertise with us. I'm going to go ahead and add our judges to the stream. Awesome. It is great to have you all. If I missed anything, I'd love to feel free to add whatever I missed from your guys' bio.
Thanks for having us.
Yeah, same as Michelle said. Just happy to be here. Thank you.
Yeah, thank you.
Fantastic. And now I'd like to introduce our competing law students. Anthony and Jada are from the Arizona State University School of Law, and Dan and Danny are from Texas Southern Thurgood Marshall School of Law. If you guys could, please give a brief introduction. Jada, why don't we start with you, then Anthony, Dan, and Danny.
Yes, good morning. My name is Jada. Like Kate said, I'm a third-year law student at ASU. I'm pursuing my JD and also a concurrent master's of sports law and business. And I'm really excited to get going on this case competition because this case is going to be groundbreaking for college athletics.
Hi, everyone. Good morning. My name is Anthony Studnicka. I'm also a third-year law student at Arizona State. Also, like Jada, pursuing the concurrent Master of Sports Law and Business degree. Really happy, really excited to be here. Thankful for the opportunity and want to give a shout out to Aaron Hernandez and everyone else back at ASU, along with our friends and family watching in, tuning in today to support us.
Hi, folks. I'm Dan Sullivan, first-year law student at TSU. looking forward to the competition. And it's been a strange time experiencing law school virtually for the entire time. So hopefully this competition is also going to just enhance that experience.
Hello, everyone. My name is Mabel Danny Crane. I, too, like Dan, am a 1L at Thurgood Marshall School of Law, and I'm excited to be here. I have experience in health law, so that is what I will be pursuing post-graduation.
Fantastic. Thank you all. And Anthony, thank you for reminding me. Shout out to Aaron Hernandez and Walter Champion, our two professor advisors for each of these teams. Before we get started, I would like to thank the students who've done an amazing job. We've thrown this competition together in under 2 weeks. So it's an incredible feat that they're able to argue this in moot court, and just exciting to have them. Before we get going, I'm going to provide a little bit of background on the case and how it's come to this point, and then we'll start jumping right into it. So let me explain some background on the Alston case, and then I'm going to turn over the teams. So the Alston case is different than O'Bannon, which was limited to name, image, likeness, because Alston was originally challenging the entire array of NCAA amateurism-based compensation limits. The student athletes originally alleged that the NCAA and 11 athletic conferences violated antitrust law by fixing the price of scholarships and other benefits, and Alston was actually arguing to create a free market. The district court found for the athletes holding that the NCAA must allow for certain types of academic benefits, such as computers, science equipment, musical instruments, and other tangible items, not including cost of attendance, but related to academics. The question is, but why was the holding about education-related benefits when Alston was originally filed to challenge the amateurism model as a whole, an attempt to create a free market? Well, this takes me back to law school. You see, the district court was bound by the O'Bannon 2 decision. And when I say O'Bannon 2, I mean the Ninth Circuit court rather than the district court. In O'Bannon, it's just an easy identifier. So O'Bannon 2 decision, which prohibited an open market for the student athlete services, and the remedy from the court was limited to education-related benefits. Basically, the O'Bannon 2 decision created an education limitation. So if Alston wanted a free market, then Alston would have to argue that O'Bannon 2 was wrongly decided at the merits phase. You can see Justice Thomas's dissent in O'Bannon 2. But to paraphrase Justice Thomas, the majority looked at whether allowing athletes to be paid NIL compensation unrelated to education is virtually as effective in preserving amateurism as not allowing the compensation. Justice Thomas said the court should have looked at whether allowing athletes to be compensated for their NILs is virtually as effective in preserving popular demand for college sports as not allowing the compensation. So essentially, should the antitrust analysis be about the concept of preserving amateurism, or preserving consumer demand with amateurism only being relevant as it relates to consumer demand? Since the majority in O'Bannon 2 looked at preserving amateurism, it provides a form of antitrust immunity to the NCAA because it forecloses the free market argument and limits the judgment to education limitations. And that is where we find the Alston case today. So I'm going to turn it over. We're going to start our great competition. And just to outline how it's going to progress, each side has 15 minutes. The petitioner can reserve up to 3 minutes for a rebuttal. And the judges, just as a reminder, can ask questions at any point except for the final minute. Please, the final minute, we will post up a banner that says a 1-minute warning. At that time, no more questions. Let the law students finish their arguments, and we will go from there. The judges have a score sheet, and there are 4 different areas that can be scored. And I will let the students actually lead into and explain the question presented and the arguments for each side. I believe Dan and Danny, are you guys up first as the respondent or as the petitioners?
Yes, sir.
Fantastic. So Texas Southern will be representing the NCAA. Arizona State will be representing Alston. And we will get started. very shortly. Perfect. So Dan and Danny, who is going to be starting off for you guys? And then please feel free to adjust the judges. I will put them up on the screen shortly.
I will be going first.
Perfect. Thank you, Danny.
Yes.
And Danny, whenever you are ready, we'll actually start the timer. It's a little bit different because we're virtual. So
Okay.
you will be responsible for your own time today, although we will throw up a 5-minute warning banner and a 1-minute warning banner just to make it as easy as possible. But feel free to start whenever you want.
Okay.
And then we'll start the time.
Greetings to our illustrious judges. May it please the court. My name is Mabel Danny Crane. My colleague and I, Mr. Dan Sullivan, are representing the National Collegiate Athletic Association today. This court is asked to select between two paths for the future of American college athletics. One path respects the precedent of sports law and allows college sports to continue as a uniquely valuable product compared to professional sports. The other path allows for the courts to act as a new regulatory agency guiding fragmented semi-professional sports leagues contrasted with a higher paid class of athletes. The NCAA has been defining the product of American amateur student athlete competition for over a century. They create and enforce a constellation of rules that have a pro-competitive effect of creating a unique product in the marketplace of entertainment. The growing popularity of NCAA competitions is a testament to that success of the pro-competitive nature of its activities. If the lower court's decision stands, this court will be replacing a unique product governed consistently by the NCAA with a chimera of future rule modifications. Whenever a student athlete can convince a judge that any given regulation could be less restrictive and still offer some distinction with professional sports, then the lower court's decision will allow for the rule change. This would entirely strip the NCAA of the position it has as the creative force that generates the unique and therefore pro-competitive product of American amateur student athlete competition. On its nose, the Antitrust Act is extremely stringent. For example, Section 1 of the Sherman Act states that every contract combination in the form of trust or otherwise, or conspiracy in restraint of trade or commerce among several states or even within foreign nations is declared to be illegal. With the exception of challenged decisions of the lower courts, every court has held that the antitrust laws do not authorize federal judges to re-engineer the NCAA's amateurism rules. That conclusion follows from the broader antitrust principle that when a joint action is necessary for a product to even exist at all, as is the case for American college athletics, we're entitled to deference in defining this unique product. On today, I will be addressing the first issue before the court, which is whether the Ninth Circuit erred in not using an abbreviated deferential review, but rather they reviewed the case under a detailed rule of reason scrutiny. The NCAA requires significant cooperation. In fact, every participating school has to agree on the rules of play and eligibility to ensure the consistency. Because this is a joint venture creating a unique product, the NCAA is in a very unique position in order to evaluate the effect of its cumulative decisions on its product. It's entitled to deference in scrutinizing its product. Allowing an external party to second guess and scrutinize every element of the NCAA process would totally undermine the value of the unique product and therefore reduce its competitive nature. The American Needle case highlights the quick look standard. Depending upon the concerted activity in question, the rule of reason, it might not require a detailed analysis. It can sometimes be applied, as the American Needle case states, in the twinkling of an eye. A hypothetical for this would be If Google and Facebook conspired together to alter the advertisement and search algorithms in order to control what we see, the rule of reason would definitely and clearly apply to examine anti-competitive effects in that case. But here, the NCAA is only regulating its internal affairs, and it's entitled to a different standard of review. Clearly, the rules regarding how the sports are played, who can play, and how they are compensated are all central to creating and maintaining the unique product that the NCAA provides and has provided for over a century. Joint product makers have the entitlement to latitude in defining their unique product. And because the definition of amateurism is central to the NCAA, the rules of enforcing that status is central to the definition of the pro-competitive product. It's not enough for student athletes to simply say that fans will still watch. They're still watching after the NCAA changed educational benefits for students in the past, because removing rules against pay to play would fundamentally change the product that the NCAA offers. And because this change is apparent, the court should have used the at-a-glance standard. The 10th Circuit Court in Law versus NCAA held that the NCAA rules defining the eligibility of participants are justifiable under the antitrust laws because they are necessary to create the product of competitive college sports. The weight of sports law clearly indicates that leagues have the ability to define the rules of play and eligibility. This court should not put a unique burden of navigating unpredictable rule of reason suits against the NCAA when professional leagues are entitled to wide deference in crafting their own rules. The rule of reason would definitely make amateur sports a mess, opening the floodgates to piecemeal close-look rule of reason suits would likely cause fans to become dissatisfied with the entanglement of inconsistent rule creation and the shift towards pro sports. The negative impact on an amateur college sports would itself be anti-competitive. For example, the Third Circuit Court in Race versus Hoosier Racing Tire has recognized that such entities deserve a bright line rule to follow so they can avoid potential antitrust liability as well as time-consuming and expensive antitrust litigation. And that contrary to the pro-competitive purposes of the antitrust law, this liability and litigation expense may have a very real anti-competitive. Oh, yes.
Yes. Thank you, Ms. Crane. Tell me, though, how this is different than price fixing. I mean, it seems to me this is exactly what price fixing and what the Sherman Antitrust Act was meant to do. It's just, to allow the competitive nature and capitalism. How is what you're asking this court to do today any different?
I feel like this is different because those encompassed several different a monopoly on it, and we're not wanting the NCAA doesn't seek a monopoly. What we seek is consistency, and so to me, that's the difference here. One of the differences here.
Well, Ms. Crane, are you contesting the holding that the NCAA and its schools operate as a monopoly already?
Not as a monopoly in the negative sense, but in the sense that they are operating as something that has, for over a century, built an effective way of keeping consistency and keeping everyone accountable and in the same pot, so to speak.
But is everyone the same?
Everyone should be the same if they are following the regulations.
The athletes are not the same, right? I mean, we have different athletes that come out all the time that should be allowed to get paid for what they're doing or the amount of time they put in or the energy or the fact that there's, consumers out there who want to buy jerseys with their names on it. I mean, not everyone is the same. Isn't that true?
With respect, I disagree. I feel that these student athletes are not without compensation. They are receiving compensation for their athletic ability and compensation that would
Does everyone have the same athletic ability?
Does everyone have the same athletic ability? No, definitely not.
Okay, so then why are they being paid the same?
I feel like they're being paid the same because when it's a team effort, it's a team sport that they're playing. It's not an individual sport. So to say this one deserves more ultimately would lead to, as I spoke to earlier, it would lead to a lot of litigation where every individual athlete would bring a case to the court, a litigation court case
Well,
to the court.
Isn't that what we already have though with walk-ons? Because for instance, in football, walk-ons don't necessarily have access to training tables. So even within the same teams, we're already treating athletes differently. Doesn't that kind of counter your argument that all athletes are treated the same?
I would disagree. Oh, I apologize.
Go ahead.
Okay, I apologize. I disagree that all athletes are, that there's a difference in that. And now specifically, there will of course be some differences. As a former student athlete, as a captain, I went to different meetings than my other teammates. So there, to whom much is given, much is required. So if your role on the team demands more of you, then you get more of the resources that are available to all, because at the end of the day, there are not unlimited resources.
So you were getting paid more than your counterparts?
No, that was in reference to your question about using the tables or different services that will be provided. If I'm not beating my body up as much as someone else, then would I need to be on the tables?
Were you saying that the
versus-
walk-ons don't beat up their bodies before games and going through multiple drills the same way that others do?
That I'm not speaking on. I would need more facts, and I've never been a part of a football team. So from what I can deduct, I would not think that they would need it as much. If they're a walk-on, are they a walk-on? Are they participating in practices?
Okay,
I would need more information.
Let's say any team, right? Is any player on a team really exempt from any aspect of practice by virtue of how much, based on how much they play in a game?
No, not based on how much they play in a game, but how much time they use for how much time they practice. If our practice is mandatory, are they in every practice? I would kind of think that every program has some type of stipulation related to walk-ons or members of the team who may practice. I am going to defer to my teammate at this time.
Yes, thank you. And just as a quick question for the timekeeping, does the questions also run into the time? So we have 5 minutes remaining?
Yes.
Okay, wonderful. Thank you. So quickly, the second argument that we are pursuing today is that even if we apply the rule of reason standard for looking at the specific regulations that are that are being challenged, this court should still allow for the NCAA's current rule set. One of the things that we have to acknowledge is that the Antitrust Act is looking specifically at economic activities. However, we need to mention that the NCAA has goals that are not market-based. So any rule of reason application must also take into account the non-economic goals, which include equitable access to athletics, sustainable financial burden for the participating academic institutions, and then also various character goals that the NCAA promotes as core to its student-athlete experience.
Counsel, excuse me, are you saying that any corporation that does civic work or firms that do pro bono, they should be exempt from antitrust simply because they also do good work that isn't related to making a profit?
If other organizations, including nonprofits, have been recognized over the decades by the courts as having a non-market purpose as part of their core function, then I think they should be allowed to access the same type of arguments that we're making here.
Where would you draw the line? What would be the bright line test for that?
So I guess a bright line test would be taking a look at the number of cases and the amount of time, and then also just sort of a core mission statement for an organization to see whether their activity is actually geared towards merely generating revenue or also serving alternative functions. So one of the things that's true of the NCAA is that most of the schools that are participating in the program aren't making a profit off of athletics. And if we look at a granular team level, it's certainly the case that the most teams in the NCAA don't make money. So applying market forces to look at all of the activities doesn't make sense, because there are larger components that deal with the schools in this particular situation.
Counselor, doesn't that make perfect sense though? I mean, look, at the end of the day, we may have fewer schools competing in the world of athletics, but isn't that capitalism at its finest?
No, because one of the things that we're competing against, so one of the things that the NCAA does is compete against the world of professional sports. So my partner mentioned that we are creating a unique product here that is standing against what we see as just a pure capitalistic cash grab in the world of professional sports, right? The fact that we're able to have under the NCAA regulating the college athletics the way that we do, we're able to actually have schools in multiple divisions pursuing, say, women's lacrosse or men's water polo, for example. Those are things that don't necessarily have any economic weight in the market, but we're actually able to increase sports viewerships for multiple teams that otherwise would not have any space within the marketplace by allowing for us to spread alternative market concerns here. Sorry, Judge, was there a question that was cut off at the end?
Sorry, I muted it because we don't want to allow questions in the last.
In the final minute. Okay, so just to wrap up with the last minute, so the NCAA, even if we're applying a rule of reason analysis to the specific rules that are being challenged, the NCAA's governance should be allowed to control, because again, all of the rules that we have are geared towards having a reasonable function that has been defined by the courts over and over again, including these other factors that the challengers would seek to upend. The NCAA is not the professional sports league. That is one of the things that we're competing against, is creating this unique product that does allow for amateur athletics, and simply saying we should be treated the same, even though every court and the entire organization's history is contrary to that, would simply change the nature of the organization. And so that's why this court should apply the quick look glance to the NCAA's internal regulations. And even if they applied the rule for reason, they should recognize that it's not just taking a look at market forces that are comparing us to, say, professional athletics. Thank you.
Perfect. Thank you, Dan and Danny. Going to switch over. Phenomenal. I'm going to just mess around here. Awesome. And then Jada and Anthony, who will be leading off for the respondents?
I'll be going first.
Great.
Good morning. May it please the court. My name is Jada Allender, and I, along with my co-counsel, Anthony Studnicka, represent the respondents in this matter. I will be addressing the issue of whether the use of the rule of reason analysis was appropriate, and Mr. Studnicka will be addressing the Ninth Circuit's reasoning that the challenged NCAA rules violate antitrust law. Your Honors, the respondents respectfully request that you affirm the Ninth Circuit's ruling and hold that the Ninth Circuit properly applied the rule of reason analysis here for three primary reasons. First, the NCAA is not a joint venture and is not exempt from a rule of reason analysis due to any purported status as a joint venture. Second, this court established in Board of Regents that application of the rule of reason analysis to the NCAA is appropriate. Third, an exemption to Section 1 of the Sherman Act, like the NCAA is requesting here, is for Congress to create. Today, you heard the NCAA argue that it is a joint venture, and that its alleged status as a joint venture entitles it to have its restraints to trade held valid and upheld without further analysis under the rule of reason. The NCAA's contention that its members operate as a joint venture in the relevant labor markets is plainly wrong. The NCAA member institutions' activity in the labor market is competing against each other fiercely for student athletes. Furthermore, even if the NCAA is a joint venture, this court unanimously held in American Needle v. NFL that rules restricting competition amongst the members of a sports league joint venture are subject to factual examination under the rule of reason. Second, Your Honors, the NCAA completely twists and misrepresents the Board of Regents case. According to the NCAA, Board of Regents requires upholding NCAA amateurism rules without a detailed rule of reason analysis. To the contrary,
how does the Board of Regents case even apply? Wasn't that dealing with television rights?
Yes, Your Honor, that is correct. The Board of Regents case deals with the television rights, and the relevant market there was the consumer, whereas the relevant market here is the labor market and the student athlete. And to that point, the NCAA's reliance on Board of Regents and misrepresentation of it here has no place. The Board of Regents clearly stated in its case, today we hold only that the record supports the district court's conclusion that by curtailing output and blunting the ability of member institutions to respond to consumer preference, the NCAA has restricted rather than enhanced the place of intercollegiate athletics in the nation's life. So yes, Your Honor, to your point, the Board of Regents case and the analysis there does not control in the way that the NCAA has brought it here.
What are your thoughts on the NCAA's argument that their rules deserve deference and that, you know, we should give them some leeway to make their rules as they see fit?
Your Honor, the NCAA's argument is based on amateurism and the idea that amateurism is different. And at the bottom line, amateurism is a factual argument and not a legal defense. The question under Section 1 of the Sherman Antitrust Act is not whether a restraint is reasonably necessary for amateurism. It's whether the NCAA's amateurism restraints are sufficiently pro-competitive to overcome the significant anti-competitive harm they inflict on the labor market. So while they may have some amateurism argument that under a factual analysis has failed under the rule of reason 3 steps, it at the end of the day is a factual argument and must go through the rule of reason analysis, which it has in the courts below and has ultimately failed. Your Honors, this brings me to my third point, that under Section 1 of the Sherman Act, agreements or conspiracies in the restraint of trade or commerce are illegal. When an exemption under this act is appropriate, Congress creates one. This court has been disinclined to create exemptions itself where Congress has not created one. To this point, just last year, the NCAA attempted to persuade Congress for an antitrust exemption through the Fairness in College Athletics Act, yet they were unsuccessful. As the NCAA referred to today, the NCAA seeks nothing less than an outright exemption from Section 1 of the Sherman Act. Although it is framed as a quick look or abbreviated deferential review, and as the NCAA has alluded to today, it is really asking that any NCAA rule related to amateurism must be upheld as lawful in the pleadings without any factual inquiry and regardless of the economic realities. Your Honors, this outright exemption, if created at all, would be for Congress to create, and they have already failed to do so in considering the NCAA's amateurism as it stands today.
Ms. Solyndra, can I ask you a quick question? So thank you for your presentation. So how does the NBA and the NFL play a role in this? Both of them have either one and done rules or rules that prevent college students, the junior rule prevent college students from actually going into the professional ranks. Can you talk a little bit about how sort of outside forces play a role in the NCAA's membership model?
Yes, Your Honor. So with regard to the NFL and other leagues' impacts on the NCAA membership model, because the members themselves are competing against each other for student athletes, that does put them under this rule of reason analysis and under this antitrust violation here. And the NFL and other leagues' similar membership structure has actually informed the court, since this court in American Needle v. NFL similarly held that although the NFL is a joint venture, that its anti-competitive practices still were subject to the rule of reason analysis. So in the way that the NFL and other leagues may have a similar membership structure, even though the NCAA, and we strongly believe, is not a joint venture, even if it was similar to the NFL or other leagues, it would still be subject to the rule of reason analysis. Ultimately, the NCAA is not a joint venture and is not exempt from a rule of reason analysis due to any purported status as a joint venture. Further, this court has already established in Board of Regents that application of the rule of reason analysis to the NCAA is appropriate. Finally, an exemption to Section 1 of the Sherman Act, like the NCAA is requesting here, would be for Congress to create. For the foregoing reasons, I respectfully request that you affirm the Ninth Circuit's ruling and hold that the Ninth Circuit properly applied the rule of reason analysis here. I now turn over the balance of my time to Mr. Studnicka.
Good morning. May it please the court. My name is Anthony Studnicka, and I'm here today representing the respondents in this matter. Today, I will be addressing the federal antitrust violation the NCAA is committing through their eligibility rules that restrict compensation for student athletes. Your honors, in order for the NCAA to be successful today, they must prove that the rules restricting compensation of student athletes is not a violation of federal antitrust law. For the NCAA to succeed, they must show that erroneous legal tests were applied to essential finding of fact, or the findings themselves were clearly erroneous by the Ninth Circuit. This argument the NCAA is making cannot succeed because the NCAA rules restrict compensation without a pro-competitive purpose, which is a direct violation of antitrust law, as held by the Ninth Circuit. The Ninth Circuit determined that these restrictions limiting student benefits constitute an unreasonable restraint of trade because under the rule of reason analysis, it was determined that the NCAA restraints were patently and inexplicably stricter than necessary to accomplish all of its pro-competitive objectives. Further, it was concluded that a viable, less restrictive alternative exists. The rule of reason analysis contains a three-part analysis and was appropriately applied by the Ninth Circuit as explained by my co-counsel. I will discuss the three steps of the rule of reason. Step 1. The student athletes met their initial burden by demonstrating that the NCAA restraint produced significant anti-competitive effects in the relevant market. The relevant market for the services of a student athlete was their services as a student athlete. Step 2. During step 2,
I'm sorry, isn't it true that the NCAA is just trying to protect their product?
What do you, thank you, Your Honor. What do you mean by their products? Can you please clarify?
Of course. I think it was on the counselors on the other side talked about they're trying to protect their product overall with all the schools, and that's why they are not having antitrust violations because everyone's on the same page. Everyone's equal.
Your Honor, that would stem from the argument that if we were to concede that the NCAA were a joint venture, which we strongly believe they are not, because they compete for the services of student athletes in the labor market, which directly makes them not a joint venture.
Mr. Studnicka, I have a quick question on a follow-up to Justice Gervais's question. So how would how would name, image, and likeness legislation across the states, or even and sort of at a congressional level, would that sort of make this case moot at all in terms of offering sort of outside sort of capitalism type benefits to these students? So that's the first part. The second question is in this idea that Justice Gervais was talking about with sort of product. Is the NCAA not a member institution? So, for example, a school doesn't have to be a part of the NCAA. You can choose to be a part of NAIA or something else. You can sort of pursue some other pathway. And is the NCAA not like any other country club where if you join, you have to follow the rules? So maybe those sort of three things. Could you address those?
Yes, Your Honor. I will take your questions in the manner that you presented them. So regarding the first one, this differs from NIL, as NIL is what student athletes could obtain outside of their university. This case is strictly about education relation benefits that student athletes could obtain from their university. In regard to your second point, because elite student athletes lack any viable alternatives to D1 athletics, they're forced to accept whatever compensation they are offered, regardless if it is reflective of what they could earn in the unrestricted market. Moving on to step 2, the NCAA was unable to justify its undisputed deviation from the operations of a free market. The NCAA was unable to demonstrate evidence of their restraints' pro-competitive effects as a justification of preserving what they refer to as amateurism. This is because while some NCAA rules may serve a pro-competitive purpose, rules restricting education-related benefits do nothing to foster or preserve demand in athletics. The district court reasonably relied on demand analyses, survey evidence, and NCAA testimony indicating that caps on education-related benefits have no demand-preserving effect and therefore lack a pro-competitive justification. Allowing schools to compete for student athletes by offering them enhanced benefits to support their academic achievement is consistent with free market principles and the mission of the NCAA. Limiting education-related benefits is not only illegal, it is ludicrous. The NCAA's stance, emphasizing the societal important non-commercial objective of higher education, is a complete fabrication. During 2020, while our country faced a pandemic, students everywhere were told not to attend class or to attend class virtually, to stay at home or stay in their dorms. Amidst this, these amateurs, as referred to by the NCAA, were asked to put their health at risk to participate in events which generate revenue for their universities. Such commercial exploitation of these student athletes is hardly indicative of a societal important non-commercial objective like higher education.
Counselor, how is this any different than what you're advocating for than pro sports?
Because the benefits we are advocating for are educationally related. This distinction is completely different from pro sports, as educationally related benefits are a direct tie-in to college athletics, and that is not similar to what you would see in professional sports.
So what other educational benefits are you advocating for?
We are advocating for, as the injunction was granted by the Ninth Circuit, the injunction would allow for the conferences, instead of the NCAA, to create rules regarding education benefits, which could no longer cap these benefits as the NCAA has begun to do. And this court must take into consideration what the NCAA refers to amateurism to do this. This court must recognize the confluence of rules which restrain some kinds of compensation, while others permit things like NCAA insurance policies for top athletes, Visa gift card as participation awards, and cash stipends as forms of compensation. This dichotomy reveals that the NCAA has abandoned any coherent definition of amateurism as concluded by the Ninth Circuit. Further limiting these forms of compensation demonstrates a predatory business practice by limiting output and engaging in price fixing. This is a direct violation of antitrust law. This court must consider how the NCAA has continued to blur their stance towards amateurism. Finally, this court must remember this amateurism assertion by the NCAA is a factual argument, not a legal defense. Lastly, step 3, the student athletes met their burden in the third step of the rule reason analysis by making a strong evidentiary showing that their proposed less restrictive alternative was viable. Academically related benefits are easily distinguishable from professional salaries as they are connected to education and cover legitimate academic costs. In conclusion, not only are the NCAA rules restricting educationally related compensation of student athletes morally questionable, but they violate federal law. As stated by Judge Smith in the Ninth Circuit concurrence, the result of this analysis seems to erode the very protections a Sherman Act plaintiff has a right to enforce. Here, student athletes are quite clearly deprived of their fair value of their services. We ask this court to affirm the Ninth Circuit in its holding as they determine the NCAA's eligibility rules restricting compensation of student athletes violates federal antitrust law. Thank you for your time and consideration.
Fantastic. Well, thank you all. That was amazing. I just want to say thank you and great job to all of our participants. That was a fantastic moot court hearing, and everyone should be proud of how well they did, especially in the time constraints that we put this all together. Judges, if you have anything that you would like to say, any feedback you'd like to give to our counsels.
Go ahead, Maddie.
All right. So first of all, Danny and Dan, I thought you guys, first of all, did a great job because I think that we were really hard on you guys going into the weeds. And I thought you handled yourselves pretty well, dodging our questions. I would say, in avoiding going down the rabbit holes sometimes, because I think some of our questions just naturally kept going there. I think, finding a better way to pivot back to your argument sometimes could be helpful in avoiding those, but I think they were pretty tough questions along the way. Jada and Anthony, I thought you guys did really great. And I think I think all of you presented extremely well. Jada, I thought your argument structure was really great, and I thought you did a really fantastic job of answering a question thoroughly and then going right back to your argument and clearly lining out exactly where you were in the argument. So that was impressive. So, but guys, all of you did a great job.
Yeah, I totally concur with everything Maddie said. Danny and Dan, you guys forgot to reserve time for rebuttal. You never want to waive that. It is so important to get the last word. I'm sure Jeremy and Maddie can tell you how important that is, in a courtroom setting. So, never give that up. And even if you accidentally mess it up, try to ask. You never know. When Dan got up, he could probably still have tried to ask for it. And you never know how the panel's going to be, even though they still may say no. I thought you guys did great. Danny, you looked like you were reading a little bit, and I couldn't tell if it was just a really bad camera angle. Because sometimes I know even when I'm looking directly at the camera, I have an extra camera, so you can't tell if you're reading or if you are actually, just had it memorized. But just try to have really good eye contact, and obviously be cognizant because you're on a computer, so it's hard to tell. Otherwise, I thought you were great. I thought, like Maddie said, we gave you some tough questions, and then we did get you to go down the rabbit hole a little bit. So I thought you did a great job with grace in handling it. And Dan, same thing. I thought you did a great job too. I thought you both were very personable, and which is always helpful. Jada and Anthony, thought you guys were great too. You obviously for different reasons have a slightly maybe different and maybe slightly easier argument. Maybe not. I know you guys could be switching sides throughout this, but I thought you both were strong as well. Anthony, you did a really good job of answering some of our questions and then bringing it right back into your argument. I thought that was really good too. So all in all, though, I thought all four of you did, a really great job, especially under the circumstances.
To Maddie and Michelle's points, again, great job, everybody. I won't waste any time repeating what they've said, but this is difficult to do, so just appreciate being able to be here with you guys. Thank you.
Fantastic. Well, thank you all for participating. Judges, I would ask that take the next 15 minutes and go ahead and email me the score sheet, and then we'll tally it up, and I'll email the participants and let them know the results for this hearing, so whoever wins can start preparing for the other side for tomorrow. Otherwise, thank you so much for participating. It's phenomenal having you all.
Good luck.
Good luck, guys.
Thank you all very much.
Thank you very much.
Thank you.
Great. Thank you all for joining us in Moot Court Madness presented by NOCAP Sports. Today we have two phenomenal teams, Baylor University School of Law and Marquette Law School as well. I'm going to introduce our phenomenal judges for this competition very fast, and then the law students that will be competing. So to start, let's meet the judges. Bart Lambergman, under his boss, Lead One CEO and President Tom McMillan, Bart Lambergman leads association advocacy on policy issues facing NCAA Division I Football Bowl Subdivision, FBS, athletic departments. In that light, Lambergman has led association working groups comprised of athletics directors and athletic department staff on issues related to name, image, and likeness, federated sports, transfer issues, sport and scholarship administration, and diversity, equity, and inclusion. He also assists the association with NCAA, federal and state legislative tracking, legal research, and writing on topical issues in intercollegiate athletics. Lambergman is now in his fourth year with Lead One, where he worked throughout law school, initially interning for former Lead One fellow Jill Bodensteiner, the former senior associate athletic director at Notre Dame, and now the director of athletics at St. Joseph's University. Thanks for being here, Bart. Len Elmore is a former collegiate basketball All-American at the University of Maryland at College Park, a 10-year professional basketball player, an attorney, and a 31-year national network sports television announcer. Elmore earned his law degree from Harvard Law School in 1987 as the first NBA player to graduate from that institution. In his career, Len has served as a prosecutor in Kings County in Brooklyn, New York, as senior counsel and partner with several law firms and CEOs and is CEO for a number of small businesses. Today, Len is senior lecturer in the Columbia University Sports Management Program, where he was awarded the 2019 Dean's Excellence Award. He is a director on the board of 1-800-Flowers.com. Len is now co-chair on the Knight Commission for Intercollegiate Athletics, where he also chairs the Racial Equity Task Force. In August 2020, Len was appointed to the Board of Advisors for the Shirley Povich Center at the University of Maryland, College Park, Merrill School of Journalism. Huge thank you to Len for joining us today. Josh Goldenberg is an associate at Cozen O'Can and has experience drafting and negotiating a wide array of documents and guiding clients through a range of transactional matters, including entity formation, financing, and mergers and acquisitions. Prior to joining the firm, Josh served as associate counsel for the Minnesota Vikings, where he was responsible for advising on a range of commercial matters, such as naming rights agreements, sponsorship agreements, licensing, media rights transactions, and investment opportunities targeting companies at the intersection of sports, media, and technology. He was also with a member of the new stadium development team and played an instrumental role in the financing, design, and construction of a new $1.2 billion football stadium in Minneapolis. Thank you, Josh. And now I'm going to let the law students introduce themselves. Why don't we start with Marquette? We have Matt, Ashton, and I'm going here, and Andrew Guzek, who was also advised by Paul Anderson at the University of Marquette Law School. And then at Baylor, we have Elizabeth Gardner and Lauren Johnson representing Baylor, with Lainey Howard as an alternate and Kathy Sears as a professor advisor. I'll go ahead and give it over to Matt and Andrew to introduce themselves.
Hi, my name is Matt Ashton. I'm a 3L at Marquette University Law School, and I'm pursuing the sports law certificate through our National Sports Law Institute. And we're just excited to discuss this case with our judges.
Good afternoon, everyone. My name is Andrew Guzek. Like Matt, I'm also pursuing the sport law certificate of the NSLI. And thank you so much to the judges and for NOCAP Sports for putting this event on. We're really excited to be with you guys today.
Great, thank you. Lauren, if you could introduce yourself. Mute. It's on mute.
Sorry. Hi, I'm Lauren Johnson, and I'm a 2L at Baylor Law School here in Waco, Texas. And I am actually considering a real estate and natural resources track, but I'm very interested in college athletics, which is why I wanted to participate in this competition.
Great. Elizabeth?
Hi, I'm Elizabeth Gardner. I'm a 3L at Baylor Law School. I plan to practice labor and employment law after I get out of law school, and I'm very excited to be here today.
Thank you. Now, we really appreciate everyone's time and participation in this. It's an incredible event that really got put together in just under 2 weeks. So incredible job by our law students to really comprehend the material and be able to argue it today is extremely impressive. And thank you for the judges also, very last minute, to be able to participate and be part of this incredible event. Thank you all. Now, before we get going, I'm going to go ahead and give a brief introduction to the case and just how it got to this point, and then we'll tee it up for the law students to take it from there. So let me explain some background on the Alston case, and then we can start a moot court competition. The Alston case is different than O'Bannon, which was limited to name, image, and likeness, because Alston was originally challenging the entire array of NCAA amateurism-based compensation limits. The student athletes originally alleged that the NCAA and 11 athletic conferences violated antitrust law by fixing the price of scholarships and other benefits. And Alston was arguing to create a free market. The district court found for the athletes, holding that the NCAA must allow for certain types of academic benefits, such as computers, science equipment, musical instruments, and other tangible items that aren't included in the cost of attendance, but they are tied to academics. But why was the holding about education-related benefits when Alston was originally filed to challenge the amateurism model as a whole and attempt to create a free market? Well, this takes me back to law school. You see, the district court was bound by the O'Bannon 2 decision, which prohibited an open market for the student-athlete services, and the remedy from the court was limited to education-related benefits. So basically, the O'Bannon 2 decision created an education limitation. So if Alston wanted a free market, then Alston would have to argue that O'Bannon 2 was wrongly decided at the remedies phase. You can see Justice Thomas's dissent in O'Bannon 2, but I'll paraphrase here. The majority looked at whether allowing athletes to be paid NIL compensation unrelated to education is virtually as effective in preserving amateurism as not allowing the compensation. So preserving amateurism being the key. And Justice Thomas said the court should have looked at whether allowing athletes to be compensated for their name, image, likeness is virtually as effective in preserving popular demand for college sports as not allowing the compensation. So essentially, should the antitrust analysis be about the concept of preserving amateurism or preserving consumer demand, with amateurism only being relevant as it relates to consumer demand? Since the majority in O'Bannon 2 looked at preserving amateurism, it provides a form of antitrust immunity to the NCAA because it forecloses the free market argument and limits the judgment to education limits. And that is where we find the Alston case today. I'm excited to let these law students take it from there and argue this case. So who will be going first? Who's representing the NCAA in this matter?
That'll be Liz and I.
Perfect. Awesome. And I'm going, and then who's going to be going first, Lauren or Liz?
Myself.
Perfect. And then I will start the timer as soon as you start. So on your go.
Okay, thank you. Mr. Chief Justice, your honors, and may it please the court. My name is Lauren Johnson, and I, along with my co-counsel, Ms. Elizabeth Gardner, am representing the petitioners in today's case. There are two issues before this court. I will be addressing the application of the deferential review, and my co-counsel will be addressing the alleged violations of federal antitrust law. At this time, I'd like to reserve 1 minute for rebuttal.
Granted.
Granted.
Thank you. Your Honors, the parties are in agreement today that the rule of reason is the proper test to use to analyze the challenged NCAA rules. However, the parties disagree about how the court should analyze step 2 of the rule of reason. The district court used a detailed analysis at step 2, but we argue that the district court should have used a deferential review as set forth by this court in the NCAA versus the Board of Regents of the University of Oklahoma. Today, this court should reverse the Ninth Circuit rule that the Ninth Circuit should have used this deferential review for one important reason. Various case law, including precedent from this court, supports the idea that the NCAA's rules are presumptively pro-competitive. In 1980, the idea of the deferential review, which is also referred to as the pro-competitive presumption, comes from this court's decision in 1984, which is the NCAA versus the Board of Regents of the University of Oklahoma. In that case, this court stated that it's reasonable to assume that most of the NCAA's regulatory controls are justifiable means of fostering competition amongst amateur sports teams and are therefore pro-competitive. To put more simply, this court said that most of the NCAA's rules are presumptively pro-competitive. The court went on to say that the preservation of the student athlete in higher education is entirely consistent with the goals of the Sherman Act. It's this language from the Board of Regents that the deferential review or the pro-competitive presumption comes from. Appellate courts have used this language since the 1984 decision to rule in favor of the NCAA and even dismissing these cases in the pleading stage. As recently as 2018, the Seventh Circuit stated that most of the NCAA's eligibility rules are entitled to the pro-competitive presumption announced in Board of Regents. The court says that they're entitled to this presumption because the rules define what it means to be a student athlete and preserve the amateur character of college athletics. In addition to the Seventh Circuit, the Fifth and Third Circuits have also ruled using this deferential review. In an antitrust case about dirt motorsports, the Third Circuit observed that courts have generally accorded sports organizations freedom to act and general deference to their rulings. The Third Circuit said that sports organizations deserve a bright line rule in order to protect themselves from antitrust liability and the time and expense of antitrust litigation. In the Smith versus NCAA case, the Third Circuit once again upheld one of the NCAA's rules, saying that it was a pro-competitive justification for the market restraint. Additionally, in McCormick versus the NCAA, the Fifth Circuit held that the Sherman Act only forbids unreasonable restraints and that the NCAA's eligibility rules are reasonable.
Ms. Johnson, may I ask the question? You're obviously balancing this part of your argument on a broad understanding of presumptive pro-competitive rules. How do you distinguish those cases you just cited from the one at hand, where we're talking about payment to players? Are there any cases that are parallel to that? Board of Regents was obviously about television rights.
Yes, Your Honor. The closest case right now is the O'Bannon case, which the Ninth Circuit decided that athletes could be paid for their name, image, likeness. However, it's our position today that the rules that were contested in the lower court about paying athletes relate to amateurism. Amateurism is the core of the NCAA and why there's a restraint on the market to begin with. As this court noted in Board of Regents, the reason that college sports is a different product than professional sports is because the athletes are amateurs and because they aren't paid to play.
So when you say amateurs, does that preclude any payments to college athletes, and that in a sense defines them as amateurs?
We define it as it would preclude payments above and beyond the cost of attendance. Currently, athletes are allowed to be paid up to the cost of attendance to attend their selected universities, and anything above and beyond that would be a payment and would make them would cross that line from amateurism to professional athletes. This decision today, Your Honors, could impact the future of college sports. If the NCAA's rules are subject to antitrust litigation, this could destroy college sports as we know it. Today, we ask this court to officially recognize the deferential review that was first recognized in Board of Regents and rule that the NCAA's rules relating to amateurism are presumptively pro-competitive. I yield the remainder of our time to my co-counsel, Ms. Gardner. Thank you.
Mr. Chief Justice, Your Honors, and may it please the court. As my co-counsel stated, my name is Elizabeth Gardner, and I also represent the petitioner in this case, the NCAA. I will be addressing the NCAA's eligibility rules. We ask this court to reverse the Ninth Circuit and find that the NCAA's rules do not violate federal antitrust laws for one reason. The rule of reason test was misapplied by the Ninth Circuit. Allowing the Ninth Circuit decision to stand would destroy college sports as we know it. Allowing the lower court's decision to stand will allow a handful of Division I schools to get a stranglehold on the college sports market, leaving smaller schools behind in the dust. Now, turning to the argument, proper application of the rule of reason analysis shows that the NCAA rules do not violate antitrust laws. This action was brought under Section 1 of the Sherman Act, which outlaws unreasonable restraints of trade. Reasonableness is then analyzed by the rule of reason, which stems from this court's opinion in Chicago Board of Trade versus United States.
Ms. Gardner, if I may, what's the issue with having states and the courts essentially regulate college sports?
Your Honor, the NCAA exists to regulate college sports. This court has recognized, for example, in the American Needle case, that sports leagues are sort of their own special beast, and they do need rules that regulate the league itself. The NCAA does need the latitude from this court to enact the rules it deems necessary to preserve amateurism in college sports, to make college sports distinct from professional sports. So, Your Honor, the court should not be playing a major role in changing the NCAA's rules, but instead the court should give ample latitude to the NCAA in making these rules.
But wouldn't you say the fact that the NCAA already allows compensation above the cost of attendance when you look at insurance policies for athletes, doesn't that undermine the NCAA's argument?
No, Your Honor, it does not undermine the NCAA's argument. While there are payments being made to students, like you said, also including things like academic or graduation awards or incentives, what we're really arguing over today are these above cost of attendance education-related benefits being potentially unlimited by schools, which eventually could reflect a professional athlete's salary, which would make college sports no different from professional sports. Now, moving on to the rule of reason test, under step 1 of the rule of reason, plaintiffs had the burden to show that there is an anti-competitive effect of these NCAA rules in the relevant market. And the NCAA concedes that the lower court properly analyzed this step. So we'll move on to the second step of the test. Under step 2, the burden then shifts to the NCAA to show there are pro-competitive justifications for their rules. Under O'Bannon versus NCAA, pro-competitive effects exist when they broaden or improve consumer choice. And here the justification is preserving amateurism. Amateurism, in turn, makes college sports distinct from professional sports, and this improves consumer choice. The Ninth Circuit erred in applying a different definition of amateurism than what the NCAA argued in the lower court, as well as what this court has recognized in NCAA versus Board of Regents. Amateurism means that student athletes are unpaid. The dictionary, Merriam-Webster's dictionary defines amateur as one who engages in a pursuit, study, science, or sport as a pastime rather than as a profession. And in turn, profession is defined as a principal calling, vocation, or employment. So that connotes really the difference is that unlimited payment that a professional athlete might receive that makes college sports different from professional sports. Now, the lower courts used a different definition of amateurism than what the NCAA argued.
Ms. Gardner, if you don't mind me interjecting here, I think it's an important question to discuss, kind of your view on whether you think amateurism really is needed to differentiate the product of collegiate athletics from professional sports.
Yes, Your Honor. Amateurism is the main distinction between college sports and professional sports, and it is important to preserve amateurism to maintain that distinction. So, for example, at the lower court, the NCAA provided survey evidence that showed about 1/3 of respondents to that survey felt that they watched college sports specifically because the athletes were amateur or unpaid as they understood it. Plus, watching amateur athletes versus professional athletes is a different scenario. Watching students come through college and potentially go to the NFL after that, you're watching somebody grow and change. You've got two different talent pools, and regulating the college sports market, the NCAA protects all college athletes that way. Sports leagues need rules in order to operate properly, to make sure that it is a relatively even playing field for everybody, to make sure that the more profitable sports programs aren't getting to grab all the talent because they have more money to throw at students. This would make sure that we don't see the same 2 or 3 teams at the end of the sports season in the bowl games. This makes sure that college sports is distinct from professional sports, and it keeps it interesting for consumers to continue consuming college sports. Finally, under step 3 of the rule of reason, the plaintiffs had the burden to show that their alternatives meet the same objectives as the rules in a less restrictive way. However, the student athletes did not meet this burden at the lower court. Their evidence did not tie in nationwide education-related benefit to consumer demand. And for these reasons, we ask this court to find that the Ninth Circuit erred in its application of the rule of reason. Your Honors, we ask this court to follow its holding in Board of Regents and give the NCAA the ample latitude it needs. Thank you.
Thank you.
Great. Thank you, Elizabeth and Lauren. There we go. And then, Matt, whenever you are ready, feel free to start, and then I will start your time.
Thank you. Good afternoon, Mr. Chief Justice and Your Honors, and may it please the court. My name is Matt Ashton, and my co-counsel, Andrew Guzik, to the side of me, are here today to present the 2 questions presented to us on appeal in the Alston versus NCAA case. I will take us through the first question, in which we argue that the Ninth Circuit was correct in reviewing this case on a detailed rule of reason analysis, and then I will pass it along to my co-counsel Andrew to explain that the Ninth Circuit was correct in their analysis of the full rule of reason analysis. So to start off, I'd like to respond to the NCAA and their reliance on the Board of Regents. What I would like to do is point out that the Board of Regents was a case decided on an output market restriction. This was a case decided about television deals and the NCAA, not about the NCAA and the student athletes. The language they draw to was dicta in the decision of Board of Regents. What we're looking at today is whether or not the NCAA violated antitrust rules and law when they have restricted their student athletes from receiving payments on education-related benefits. And for this reason, we have to go into a full look rule of reason. What the NCAA is asking you to do is to take the precedent from Board of Regents and apply it to an input market, which essentially would create a antitrust exemption for the NCAA. Therefore, for them, it would be, as long as we say it relates to amateurism, then we're good, and there is no antitrust. There is no antitrust violation. What we're asking the court today to do is to uphold the Ninth Circuit decision to review it in a full look analysis and analyze it fact by fact for each scenario when dealing with the payment to the student athletes on educational related benefits. What the key point for us was when the Ninth Circuit had pressed the NCAA on their definition of amateurism. And when pressed by the Ninth Circuit, the NCAA has continually flip-flopped on what they believe their definition of amateurism. If it truly is that it's to not pay student athletes for benefits that aren't related to educational benefits, then their rules contradict themselves. They have benefits related to full cost of attendance and beyond that. They give stipends for certain reasons that other students don't get. So for them being a student athlete, they are already getting benefits per NCAA bylaws. And the NCAA may argue that the purpose of their rules on amateurism is to distinguish their lines and not to blur the lines between professional sports and college athletics, thereby creating the same product. They want to create a different product, right? Is that we've seen that these full cost of attendance payments have been allowed. We've seen the stipends being allowed, and we haven't seen a loss of interest in college sports. So for them to assume that as long as, yes.
Can you explain why this court should not grant an antitrust exemption for the petitioners when we have made an exemption for baseball in the past?
Yes, Your Honor. This court should not create an exemption for the NCAA because that is the job of the Congress. Congress is there if they want to put the legislation in to create an exemption in which it allows NCAA to regulate the amateurism sports, then they are full and free to do so. However, at this point, we do not have an exemption out there, and it's not a court's job to create an exemption for the NCAA. And by allowing the NCAA to apply a quick look rule of reason analysis to any questions of amateurism is essentially creating that exemption for them.
Let me go back to your reference to dicta. On what basis do you interpret the statements in Board of Regents that seem to be favorable to the NCAA? On what basis do you term that as dicta?
Yes, Mr. Chief Justice. The reason we base that on dicta is because in Board of Regents, what they were dealing with in that fact scenario was the contract between television deals and the NCAA. That was an output market restraint. And in that, you can see a twinkling of the eye of why that amateurism may be a pro-competitive justification in an output market restraint, and why that analysis had to be a full rule of reason. And the court ultimately decided that they violated the antitrust rules. Here, we're dealing with an input market restraint. And that's why we need to make sure we are analyzing fact by fact scenarios of why these rules would be pro-competitive and what they're doing anti-competitively to balance that out. So while we appreciate the Board of Regents decision, we understand it to mean that in output market cases, there has to be a full rule of reason, and the extra language in that case was not pertinent to our argument here today, in which we're dealing with an input market. So overall, what we're doing today is asking the court to rule that the Ninth Circuit was correct when they decided not to apply a quick look rule of reason and apply the Board of Regents analysis, in which that amateurism would be a quick look rule of reason and defeat any anti-competitive effects. We asked the court to uphold the Ninth Court decision on applying the full look rule of reason analysis, and now I will pass it to my co-counsel to explain why the full rule of reason analysis was applied correctly by the Ninth Circuit Court.
Well, thank you very much to my co-counsel, Matt, and good afternoon, Mr. Chief Justice and Your Honors, and may it please the court. Following off of what my co-counsel said, that the Ninth Circuit was correct in using a full look rule of reason, I will now speak as to how their analysis under the full look rule of reason was correct in determining that the NCAA's restrictions on monies received related to education is a violation of federal antitrust law. So in order to look at the full look rule of reason and to see how it applies to a case like this, there is a 3-step analysis that needs to be done. Initially, the student athletes were tasked with proving their meeting their burden of proof by showing actual anti-competitive effects suffered by this restriction by the NCAA. And as petitioners, as the NCAA pointed out, both parties agree that the restriction that was, the anti-competitive effect that was pointed out by by Alston in this case, and the student athletes, was true. So then we switch over to step 2, where we talk about what the NCAA puts forward as a pro-competitive justification for doing so. And as the NCAA has done at just about every other level of court, they have gone with the amateurism model. And as my co-counsel pointed out, we have seen the amateurism argument sort of very much change over the past few years. We talk about how in O'Bannon, while O'Bannon was dealing with name, image, likeness rights, and this is dealing with the benefits related to education, they determined that providing the money up to full cost of attendance was appropriate and as an extra benefit. They've also talked about adding over time laptop computers, laptop computers, student athletes, stipends for certain travel expenses, those sort of things. And, when we talk about, is this blurring the line between pro sports and amateur sports at the NCAA and the professional level, as my co-counsel said, providing that money up to the full cost of attendance does not affect whether or not the common viewer of college sports is watching that sport because they know how much that player is being made. It doesn't make a difference to them. So it's not affecting the consumer perception of it. And the district court came forward after determining, and so this is the 3rd step of the rule of reason analysis, the district court came through with their less restrictive alternative, which allowed at the conference level to be approved by the NCAA a certain cap on the amount of monies that can be received from education-related activities. Now, the problem we have, as now we think of course the Ninth Circuit was correct in using this full analysis. That still, while they understood the blanket restriction by the NCAA to be a federal antitrust violation, replacing it with a cap that can be justified by the conferences at the number that they disclosed is further an antitrust violation. We're replacing a restriction with a less restrictive restriction. So, and how this could be any different, if allowing these athletes to make money off of their education-related expenses by virtue of them being student athlete, we don't see how it can be much different than a full scholarship musical student who is given money to purchase a violin or something like that. And
but sir, who is the musician competing against?
Yes.
Who is the institution in utilizing the musician? Who are they competing against?
Yes, thank you, Mr. Chief Justice. As far as who the musician's competing against, it's not so much obviously, to the same extent in which college athletics are competing against. However, as much as, there's different musical programs across the country, being able to provide a violin to a full cost of it, let's say it's, obviously be a musical scholarship, being able to provide a violin, that doesn't affect, it's almost in putting the same hat on what the NCAA is doing. If you can provide those education related expenses, it's not going to affect the competitive market of whether a football or basketball player is going to go to one school or another, similar to how, as long as, it's allowed to provide a violin to a music student, they can have a choice to go to whatever musical program they want to. So what we're saying here, and as my co-counsel has addressed, this is not the room for the Supreme Court to create an antitrust immunity to the NCAA by just allowing them to say amateurism for everything. They've been challenged on what amateurism is to them based on their activities over the past few years.
Mr. Guzik, if you don't mind me interjecting.
Of course.
So are you saying that there should be no cap on these type of education related expenses and other expenditures, or are you should there be any guardrails, any regulation around these types of items?
Thank you, Your Honor. In regards to whether or not there should be guardrails or whether there should be restrictions, when we're talking about simply benefits related to the education process, we're not talking about pay for play here. We're not talking about name, image, and likeness. That is another discussion to have, but simply for the fact of benefits related to education, which the NCAA has allowed in certain other instances, we believe there should not be a restriction on those sort of things. That way, these athletes can provide for their, being able to receive these sort of things allows them to, especially when it's tied into education, provide further for themselves as other students would be able to. We're not.
So, Mr. Guzek, under your position, would it be okay for institutions, utilizing the same reasoning? Would it be okay for them individually to set their own limits to payments and compensation without any collusion among other institutions? Would that work?
Well, Mr. Chief Justice, I would worry about that sort of thing happening, because it seems like if they were able to set their own limits, starting to get into more of what there could be the collusion, or kind of get back to where we started on how this could be another restriction.
But isn't that what you're arguing, that the NCAA has essentially, as a cartel with their member institutions, have set limits, and that obviously is anti-competitive. So why not allow the institutions on their own to set the limits individually without collusion? Wouldn't that be less restrictive?
Certainly it would be less restrictive in the sense that they can set to whatever they want. However, we would worry about how that could create another sort of issue with competitive balance. If, let's say, one school sets it just below infinity to where you can make as much as you want, and another school caps it at a small amount, that's going to cause an issue in of itself. And schools with larger budgets are going to be able to, dominate the circuit. So where that's not where we necessarily want to go with it, we think that allowing, as far as when it comes to education related expenses, that this sort of thing should be allowed. So in conclusion, what we've talked about with this full look rule of reason is that the NCAA should not be able to put these sorts of restrictions on. It's a federal antitrust violation. We asked the court to affirm the Ninth Circuit's decision in doing that, but then also we would ask to fully enjoin the NCAA from doing this, as the restriction put on by the district court essentially is another blanket exception done in a different way. So thank you so much, Your Honors. Thank you very much to the competition, and take care.
Great. And then Lauren or Elizabeth, who's going to be taking the 1 minute rebuttal that you guys reserved?
It's me.
Perfect. As soon as you're ready, I'll start the 1 minute.
May it please the court. Your honors, a couple brief points on rebuttal. Chief Justice Elmore, you're absolutely right to point out to opposing counsel that college sports is a different beast than something like music programs at colleges. College sports require rules so that the league can function properly and engender competition amongst the colleges and the students. That requires rules. Further, opposing counsel has told this court that they're not asking for pay-for-play incentives, but in reality, that is what they are asking for. Should the lower court's decision stand, these incentives and education-related benefits could function as the equivalent of a professional athlete's salary. For example, a college could offer a post-eligibility internship for tens or hundreds of thousands of dollars to college athletes to complete to be paid after they have played for their eligibility years. Thus, we ask this court to reverse the lower court and find that the NCAA's rules do not violate antitrust laws. Thank you.
Thank you.
Awesome. Great job, everyone. That was a phenomenal hearing to watch. Everyone did phenomenal. Thank you so much. Andrew, Matt, and Elizabeth and Lauren. I think you guys did an amazing job. Thank you for our judges as well. Judges, is there any feedback that you guys would like to give, or helpful critiques, or anything about the competition?
Well, first of all, I'd like to thank the participants. You guys did a terrific job. I know what it's like. I can even remember that far back in Moot Court, the difficulty and some of the vexing questions that we might have as judges. But the only thing I would say is, to remember your core thesis and to try to stick to it. And Andrew, what I was trying to kind of throw you a softball with regard to, institutions setting their own limits and getting away from any type of collusive activity. I think that is something that, in fact, that the Alston side would actually want, on the basis of the fact that the alternative would be the NCAA once again having their institutions and essentially in a collusive sense be able to set limits. But again, staying with your core thesis, I think the four of you did a mighty fine job. I don't know what my colleagues have to say, but thank you anyway.
Yeah, I would echo Len's thoughts, and clearly you all knew the record very well, and even the public policy arguments. There's a lot to be said about should Congress be involved, should the states be involved, and you all knew that. And when we did ask the questions, you were able to stay on track. So I know you all have your own coursework, and so you clearly put a lot of preparation. So I commend all involved.
Yeah, I agree with everything that's been said. I think first off, sometimes in this remote setting, these things can be more challenging than when we're live in person. But I thought that you all handled those unique challenges with professionalism and did an outstanding job of articulating your points. And really, Elizabeth and Lauren, I thought you did a great job kind of staying on your talking points and reiterating some of the key concepts that you wanted to get across. I thought that was very effective. And Matt and Andrew, I thought you two had a great grasp of the subject matter, and I thought the way that you responded to our questions, which can be, difficult as a law student to think on your feet, and I don't think being perfect is the goal, but I think just the poise that you had in responding to those questions, was something that was outstanding. So I thought everyone did a great job.
Let me add one thing though. As Josh said, thinking on your feet, don't get comfortable, because you guys were sitting down, and it is a vastly different experience standing up. So, just keep that in mind on the next go round.
Great. Well, thank you so much for the judges and all of our participants. I should have said this at the beginning, but I keep forgetting, so I'm going to say it now. I'm going to explain NOCAP's mission to everyone watching. NOCAP's mission is to give every athlete, regardless of school, sport, level, and background, equal access to the best technology, resources, and sponsorship opportunities to succeed in the NIL era. The NOCAP marketplace allows for athletes, brands, and agencies to come together on one platform and execute meaningful partnerships. NCAA compliance rules are automated in the system for college athletes, NCAA, and schools in order to protect athletes and eliminate the compliance burden facing every institution. Thank you so much, everyone, for participating. I can ask the judges to please please email me the score sheet sometime in the next 30 minutes, please. And then I'll notify our participants so they can prepare for tomorrow if they need to. Otherwise, thank you so much, everyone. Everyone did a phenomenal job.
Thank you, Casey. Thank you very much, judges. We really appreciate your time this afternoon.
Thank you.
Thank you all. Good luck.
Yeah.
Awesome. Welcome back to NOCAP Sports Moot Court Madness. This is exciting. We have two fantastic teams here, UCLA and Harvard. Thank you so much, everyone, for joining us, and the judges as well. I'm going to do a brief introduction with all of our judges, and then I'm going to kick it off back to the law students to do their own introductions. So, to start, Sarah Hartley is a partner in the Boulder office of Bryan, Cave, Layton, Paisner, practicing in the commercial litigation and antitrust groups, co-chair of the higher education team, and a member of the sports and entertainment group. Sarah has worked with sports clients in the Olympic movement, professional sports, and collegiate sports, and is regularly consulted on safe sport matters, Title IX, governance, and ethical issues. She has handled numerous contentious disputes regarding allegations of sexual misconduct by coaches, athletic personnel, and others, and has assisted in the development of safe sport policies and arbitration procedures for the new U.S. Center for Safe Sport. Sarah also serves as an advisor to universities on Title IX compliance, including preparing and reviewing policies and procedures, training, and consulting on the handling of allegations of Title IX violations. She also teaches sports law at the University of Colorado School of Law. Thanks for being here, Sarah. From athlete to advocate, former basketball player and attorney Ebony McHugh serves as Chief Legal Officer of OMBI Group LLC, a premier sports and entertainment firm. She oversees business and legal affairs, risk management, and ensures company and client practices are compliant with professional sports leagues, regulatory authorities, and players' associations. McHugh also serves on the advisory board of the Entertainment and Sports Law section of the State Bar of Georgia and Winning Edge Leadership Academy. She is a Diversity and Inclusion Committee appointee and regional captain of the Sports Lawyers Association, a judge with the Atlanta Urban Debate League, and an affiliate of the Institute for Sports and Social Justice. Thank you for joining us, Ebony. Richard Friedman, the Aline and Alan F. Smith Professor of Law, is an expert of evidence and U.S. Supreme Court history. He is also one of the few scholars developing a new field that examines sports and games as legal systems. Professor Friedman is also the general editor of the New Wigmore, a multi-volume treatise on evidence. His textbook, The Elements of Evidence, is now in its 4th edition, and he is co-author of Park and Friedman's Evidence, Case and Materials, now in its 12th edition. Professor Friedman earned a BA and JD from Harvard, where he was an editor of the Harvard Law Review and a DPhil in Modern History from Oxford University. He clerked for Chief Judge Irvin Kaufman of the U.S. Court of Appeals for the Second Circuit, then practiced law in New York City. He joined the University of Michigan Law faculty in 1988 from Cardozo Law School. Thank you, Richard.
Nice. Glad to be here.
It's fantastic having everyone. I really appreciate all of the amazing students and practicing attorneys, professors, and legal professionals generally that have become judges for us. This is an incredible event, and we are so excited to have you. I just want to give a lot of credit to the law students. This competition came together in about under 2 weeks. So the fact that they are prepared to argue today is an incredible feat and really deserves admiration. And thank you, judges. I'm going to go ahead and start with UCLA for introductions. I'm going to throw it over to Grady, and then one by one we'll go David and then over to Harvard. Grady, please introduce yourself.
My name is Grady Howe. I'm a 3L at UCLA School of Law. I also played Division I soccer at UCLA as an undergrad, so I'm excited to participate in this competition.
Great.
How's it going? My name is David Akuri. I'm a 3L at UCLA School of Law. I'm in Dallas, Texas currently, and I was also a Division I athlete at Georgetown University where I played football.
Awesome. Ellie?
Well, thank you, Casey. My name is Eli Nachmani. I'm a second-year law student at Harvard Law School, where I'm the incoming co-editor-in-chief of the Harvard Journal of Sports and Entertainment Law. I majored in sports management as an undergrad at NYU and could not be more excited for today.
Great.
Hello, everyone. My name is Kit Matwire. I'm a second-year law student at Harvard Law School. I also played Division I basketball as an undergrad at Harvard, and I'm thrilled to be here, and I hope everybody's doing all right with this ongoing pandemic.
Thank you, Kit. Fantastic introduction, everyone. Thank you again to everyone that's participating. I'm going to give a brief background on the case to lead into the moot court competition for today, and then kick it off with our law students to start. So, the Alston case is different from O'Bannon, which was limited to name, image, likeness, because Alston was originally challenging the entire array of NCAA amateurism-based compensation limits. The student athletes originally alleged that the NCAA and 11 athletic conferences violated antitrust law by fixing the price of scholarship and other benefits. And Alston was originally arguing to create a free market. The district court found for the athletes, holding that the NCAA must allow for certain types of academic benefits, such as computers, science equipment, musical instruments, and other tangible items, not including cost of attendance, but associated with academics. But why was the holding about education-related benefits when Alston was originally filed to challenge the amateurism model as a whole and create a free market? Well, this actually takes me back to law school. You see, the district court was bound by the O'Bannon 2 decision, which prohibited an open market for the student athlete services, and the remedy from the court was limited to education-related benefits. Basically, the O'Bannon 2 decision created an education limitation. So if Alston actually wanted a free market, then they would have to argue that O'Bannon 2 was wrongly decided at the remedies phase. You can see Justice Thomas's dissent in O'Bannon 2, but just to paraphrase so we all understand what the basis is. The majority looked at whether allowing athletes to be paid NIL compensation unrelated to education is virtually as effective in preserving amateurism as not allowing the compensation. Preserving amateurism, though, is a key. However, Justice Thomas said the court should have looked at whether allowing athletes to be compensated for their name, image, likeness is virtually as effective in preserving popular demand for college sports as not allowing the compensation. Essentially, should the antitrust analysis be about the concept of preserving amateurism or preserving consumer demand, with amateurism only being relevant as it relates to consumer demand? Since the majority in O'Bannon 2 looked at preserving amateurism, it provided a form of antitrust immunity to the NCAA because it foreclosed the free market argument and limited the judgment to education limitations. And that is where we find the Alston case today. I'm so excited to kick off this moot court competition with these phenomenal student participants. Thank you again, Ellie, Kit, Grady, and David. So, who will be starting us off on behalf of the NCAA petitioner?
That'll be UCLA.
Fantastic. And Grady or David, who will be going first?
I will.
Perfect. Okay. And Grady, whenever you are ready, I will start the time on your go.
As a preliminary matter, we'll like to reserve 3 minutes for rebuttal.
So granted. Thank you very much. And judges, as a reminder before we get going, you're free to ask questions throughout. I will put up a 1 minute warning, and at that time, there's no questions during that 1 minute, so we can let the students finish that thought and their argument. But otherwise, feel free to ask questions anytime. On your go, Grady.
Thank you. As I mentioned, my name is Grady Howe, counsel for petitioner NC2A. May it please the court. Today's case involves preserving a wholly unique product to the world of athletics, the opportunity to pursue a professional athletic career and achieve a degree simultaneously, something that exists nowhere else in the world. In order to preserve this product, the court today must rule in favor of the NC2A. Any other result threatens the viability of the great institution of college athletics. Before the court today are two issues. One, that the NC2A concept of amateurism should be reviewed deferentially without a detailed analysis. And two, that even without an abbreviated analysis, the Ninth Circuit and District Court erred under a full rule of reason analysis and should be reversed. And the first point today is that the NC2A concept of amateurism should be reviewed deferentially without a detailed analysis because the NC2A has 100 years of preserving and promoting collegiate athletics.
Counsel, I'm sorry, Counsel, before we get into the meat of the argument, could you lay out for me just what's at stake here in concrete terms? What is it that the order below requires you to allow that you haven't been allowing up till now?
Yes, Your Honor. What the injunction requires is it enjoins the NC2A from restricting expenses related to education. And what that does is what happened was the district court took into its own hands to define what amateurism really means. And in doing so, created an injunction in which it said, NC2A, we don't trust what you've done thus far in the past 100 years in defining amateurism. What we're going to do today is actually enjoin you from restricting what you've been restricting. And in doing so, what our case essentially is that the injunction will allow litigation that could result in above cost of attendance expenses and awards.
Well, that's what I'm trying to get my hands on. Just what is it? If you can be as precise and particular as you can, what is it that are educational expenses that aren't already covered by cost of attendance? Because you're already allowing cost of attendance, right?
Yes, precisely, Your Honor.
So I'm trying to figure out just what this does that isn't already covered.
Well, that in and of itself is the problem, is that cost of attendance already allows educated related expenses, among other things, such as tuition, housing, books. But what the injunction does is it allows more than what cost of attendance already allows. And we've, so, Your Honor, let me, I can access that for you. So for example, other intangible items is a phrase in the injunction that will allow a lot of litigation. It's wholly overbroad. Number two, it allows internships, and it does not define what those internships are limited to. And so potentially a university could, in advance of recruiting a student, promise them an internship at something like Nike, where they would be paid unlimited amounts, because what the injunction does is allowed unlimited amounts related to education. And if that internship is related to education, then they could be paid unlimited amounts through that internship. It's a huge problem and essentially turns it into professional sports with a loophole. And so with the proper legal advice, they could easily be paying their student athletes hundreds of thousands of dollars.
Are Nike internships allowed under the injunction? I thought that your opponent said that it would not be, that commercial internships were not. But am I wrong about that?
So the what the court did in its injunction is technically allowed the NC2A to kind of have jurisdiction over the scope of the injunction. Mm-hmm. But the problem here is that insofar as the injunction was issued, it said that the amounts could only be paid from conferences. That was the limitation on the injunction. And the problem with that is potentially with the proper legal advice, these internships could pay the money to the conferences, which in turn funnel it down to the schools, which in turn funnel it to the athletes. And it would be in their interest to do so because the conferences and the individual teams are in competition with one another for championships and revenue.
Sure. Thank you.
Absolutely. So the first point, which I've already addressed in part, but I would just like to make clear today, is that the concept of amateurism should be reviewed deferentially for 3 reasons. One, that as a matter of law, additional products are presumed pro-competitive. 2, that the NC2A offers this new product. And 3, it's the definition of amateurism that is essential in providing this new product that the NCAA needs jurisdiction over in order to preserve intercollegiate athletics. Seeing that my personal time has run, I will hand the rest of the argument over to my co-counsel, Mr. Kerr.
Even without a quick look differential abbreviated analysis, the Ninth Circuit and the District Court still erred under a full rule of reason analysis because the NCAA eligibility rules regarding compensation for student athletes do not, in fact, violate antitrust federal law. And therefore, this case should be reversed. First and foremost, the Ninth Circuit wrongly defined the central feature of the product amateurism. The law clearly defines amateurism and gives the NCAA authority to do so based on precedent and based on the Board of Regents.
Excuse me, Counselor, is it so clear? I mean, as I understand it now, universities are allowed to pay insurance for their athletes, insuring them against injury?
Yes, Your Honor. That is just one of the...
That's pretty valuable, isn't it? I mean, that's pretty valuable compensation to the athlete, isn't it?
The NCAA wouldn't consider that as compensation. They would consider that to be a carve-out, one of the exclusions that protects student athletes with the incentive and with the purpose of having student athletes first and foremost interest at heart. So the insurance that...
That's pretty conclusory to me. I mean, I guess I'd say then, well, maybe you shouldn't consider an internship compensation, but an educational experience.
Well, the NCAA would say that an internship that provides for a specific student athlete, maybe a star athlete or star quarterback or a big time football player that happens to be $100,000 to maybe $500,000 internship allegedly would be compensation. It would just be disguised compensation. And it would go against everything the NCAA represents in terms of being the pay-to-play model. So they want to avoid this pay-to-play model and any camouflage idea of a pay-to-play model for that purpose.
Counsel, one more question along those same lines. Hasn't the NCAA's definition of amateurism kind of morphed over the years? The things that you permit have varied and in fact have changed in recent years quite dramatically. Doesn't that kind of fly in the face of this notion that amateurism is something that's fixed and could be subject to a deferential review no matter how you define it?
No, Your Honor. We believe the NCAA stands firmly that for the past 100 years, the amateurism concept has been no pay to play. So in order to maintain that amateur status, they have a no pay to play status. While there are carve-outs and many exceptions, these exceptions are all valid. And the NCAA has been progressive in terms of aligning more stuff in items in terms of cost of attendance and benefits and compensation that work for the student athlete's favor.
Counselor, how can you say no pay to play when there are athletes who are at universities who are on full scholarship, getting the value of a university education, when we understand that they wouldn't be there if it weren't for their athletic ability? Why aren't they already being paid to play, but just limited amounts? That is limited by what the cost of attendance are.
Yes, Your Honor. The athletes aren't being paid to play. We reiterate that the athletes are coming to these schools with the purpose of coming there for an education. While many of these athletes are potentially going to go on to play professionally, at the moment, they are student athletes first and foremost, and their education isn't considered to be a payment for them. It's considered to be an opportunity for them to get educated, hopefully graduate, and then be able to support their alumni, support their old schools, and advocate for their old schools and cheer on their old schools, and the other amateur student athletes who are coming through the school currently.
Yeah. I mean, they're certainly getting something of value.
It is a great value, to be honest, but this value allows for them to get an education, which is the NCAA's first and foremost main concern.
Thanks.
So the Ninth Circuit's definition was wrong in terms of not unlimited amounts unrelated to education. The definition of student athletes to amateurs still get paid in large sums. So if these large sums, similar to the example of the internship, the Nike internship that a student athlete may get, this is essentially a faux salary. And having unlimited amounts would just simply be something that pro athletes don't even get themselves. Pro athletes have a cap. For example, the NBA, NFL, and MLS all have caps in terms of what payments and unlimited amounts that they can get, and limited amounts that they can get. The G League is paid even smaller amounts of money, and certain players won't ever see the amount of money that professional athletes get. There's a reason that the NCAA has the incentive of capping these sports and capping these limits, because they want to have a clear demarcation between professional sports and student athletes. Essentially, we will yield the remainder of our time for rebuttal. Thank you.
Thank you. And for Harvard, Kit or Ellie, who is going to start? Sorry, what was that?
It'll be me. I'm going to argue the first question for Harvard. This is Ellie.
Great. Okay. When you're ready, we'll start the timer.
It sounds great, and I apologize at the outset. I'm in a hotel today, and the Wi-Fi is not excellent. So if I'm audible, I think that's the baseline, and if I'm visible, I suppose that's a nice bonus. But my name is Ellie Nachmani, along with my excellent co-counsel, Kit Matoyer. I will be arguing for the respondents Alston et al. In this case. I'll be taking the first question. She'll be on the second one. Your honors, and may it please the court. Using the quick look doctrine to uphold the restraint of trade at issue in this case would betray the court's long-standing approach to antitrust scrutiny, both as a general matter and in the context of sports law. Judge Wilkin was correct to not engage in the sort of abbreviated deference for which the NCAA argues when she proceeded to a sober analysis of the challenged restraint under the rule of reason. The Ninth Circuit was right to affirm the district court on this issue, and we urge that this court do the same for three reasons. First, the NCAA's request for abbreviated deference in cases like this one is an extraordinary ask of this court, generally unsupported by the case law and imprudent as a functional matter. What courts have called the quick look doctrine is a method of antitrust scrutiny usually reserved for invalidation of unlawful restraints of trade, not approval of them. This is for good reason. Second, to the extent that courts see fit to accord some measure of judicial restraint in antitrust challenges to sports leagues and other joint ventures, such restraint applies in particular circumstances, the likes of which are not before the court in this case. The NCAA engages in a bait and switch, describing the classic rationale for antitrust deference to sports leagues on a certain class of restraints, then quickly arguing for application of that deference to a new type of restraint. The court should reject this gambit. Third and finally, the NCAA attempts to appropriate the language of Board of Regents, but in so doing, it cherry picks lines from a case it ultimately lost, wrongly cites dicta as applicable authority.
Well, can I stop you there, Counselor? I mean, the Board of Regents case clearly did stand for the principle of amateurism in college athletics, right? I mean, it asserted that very clearly. You might argue as to whether it's dicta, but the court was much more than perfunctory in asserting the importance of amateurism. Right?
Well, Justice Friedman, I think you're exactly right, Your Honor. And I would say that in that case, what was going on was that actually the court was reviewing the 10th Circuit's use of the per se rule, and instead decided to engage in a rule of reason analysis. So that was far different.
Okay. All right, but amateurism was asserted to be and taken as a good. So, we can talk about quick look, we can talk about dismissal on the pleadings, but what the NCAA is saying is we're still adhering to amateurism. It's a fundamental aspect of what we do. It has been for 115 years and more. So why shouldn't this just be disposed of quickly? They're protecting amateurism. This court has said amateurism is to be protected in this context. End of case.
Well, I think, Your Honor, what Justice Stevens was saying in that case, he said most of the regulatory controls of the NCAA. He didn't say all. May be presumed to be pro-competitive. But as this court has engaged in rule of reason analysis as recently as 2018 in the Amex case, what we see is that the mere pro-competitiveness of restraint of trade does not lead, on its face to the blessing of that restraint. You still need to go through the full rule of reason analysis. And so to stay with some level of fidelity to the Sherman Act and to put this within the rule of reason analysis that has animated this court's jurisprudence for a very, very long time, what you want to do is go through the different steps and make whatever that restraint of trade is, which Congress has made the decision is not good just as a matter of organizing our markets, run the gauntlet of the rule of reason. And so, the mere idea that, okay, well, amateurism may be presumptively pro-competitive does not just alone justify the blessing of that restraint. And I think, this goes to the misreading of Board of Regents by petitioners in this case. Board of Regents was a case in which they lost, and the question of amateurism regulatory controls was discussed, to be sure, in Justice Stevens' opinion. But I think the better way to look at this is to actually go to footnote 7 of the American Needle against the NFL case from 2010. And in that case, the court chastised the NFL for trying to create what was, in essence, a zone of antitrust immunity. That's what the NCAA tries to do here. The NFL said, we have this licensing scheme that we want to engage in. And if you don't uphold the licensing scheme, what's going to take place is we're going to have a product that does not look like NFL football. And what the court did was it distinguished. It said, well, hold on a second. There are two kinds of things that are going on with sports leagues in the antitrust context. There's one that Judge Bork has written about in the antitrust paradox, and Judge Easterbrook wrote in the Chicago Professional League case, that a league with just one team would be like one hand clapping. Okay, there are certain restraints that you need for a league to exist and for a league to go on. But that is wholly different from the kind of restraint that was discussed in.
Sure, but here the good is amateurism. I take it that you're not denying that amateurism is something that the NCAA ought to be able to protect.
No, Your Honor, so long as the NCAA is able to make that argument in favor of amateurism within the context of the rule of reason analysis. And that's what we think Judge Wilkin did.
What's unreasonable? I guess I don't understand if amateurism is a positive good, that the product that they're creating is that they're allowed to create a product with amateurism, then I don't understand how further taking the rule of reason it gets you anywhere. I mean, because obviously it's then saying that we won't compete with respect to compensation because we're not going to pay compensation. And if we think that's good, as we just said in the Board of Regents case, then I don't see why there's any further analysis.
Well, Your Honor, and I'll leave the exact back and forth on the way in which the district court engaged in the rule of reason analysis to co-counsel who's discussing question 2. What I will say is this: the NCAA attempts to make a distinction between the amateurism, call it amateur football, college football, whatever you want, and professional football. But that's exactly what American Needle chastised the lower court for creating a zone of immunity for in footnote 7, when it said, of course, the cartel product will be different than the regular product, but that doesn't mean that it's presumptively upheld with some sort of deferential analysis under the rule of reason, and that to stay true to the Sherman Act, you want to make sure that you're engaging in a rule of reason to bless a restraint. For that reason, we ask that the court proceed past this argument, and allow the full rule of reason analysis to take place. And at this point, I'll hand it over to my stellar and talented co-counsel, Kit Matoyer, to argue the second question.
Thank you very much, Ellie. Good afternoon, and may it please the court. The players here have met the rule of reason's extremely high standard, not once, but twice. And now the NCAA wants a third redo. But trials aren't at bats. You don't get 3 strikes before you're out. To overrule the lower court's analysis in favor of the NCAA here would not only undermine the very purpose of the Sherman Act, which is the vindication of an injured party's rights, but also the relationship and the treasured relationship between our trial and appellate courts. The Ninth Circuit was correct to affirm the trial court's analysis, and we urge this court to do the same for 3 reasons. First, the NCAA badly distorts what we argue is a narrowly tailored and carefully balanced injunction that remains faithful to the underlying purposes of the Sherman Act while adhering to this court's teachings and Board of Regents, that the NCAA does need ample latitude. Second, the NCAA posits various legal errors on appeal that aren't only unavailing, but we argue just thinly disguised factual disagreements. And third, the NCAA's pro-competitive justification of amateurism is just both incoherent and unworkable as a practical matter.
So Counselor, I'm sorry.
Counselor, quick question for you. So would impending state legislation around the NIL laws completely invalidate the NCAA's amateurism argument?
Well, Your Honor, I urge, this rings of O'Bannon, and what was at O'Bannon is the name, image, and likeness. But here, it's really just the narrow issue of education-related benefits. And so under the current statutory framework that the Sherman Act provides us, the players here are just walking into federal court wanting these particular injuries to be vindicated. And that's just this narrow issue here, and that the injunction plainly gets to. And this goes to just the distortion of the injunction. The plain meaning is clear. Judge Wilkin properly balanced the interests here. She managed to vindicate the players' rights while giving the NCAA the most deference. She rejected 2 much broader alternatives in favor of the one that would allow the NCAA to govern much like they do, with the exception of this one violation of antitrust law. So here, for example, far from micromanaging, under the injunction, the NCAA is invited to do a number of things. One, they're invited to define what education-related means. With the approval of the court, they get to set that definition. 2, they also get to determine how these benefits are to be distributed. And they've already done this. There was a doomsday hypothetical that the NCAA offered that basically said to the tune of Alabama's offensive linemen will all be driving Bugattis, or the uncapped postgraduate internships provided by boosters. But this ignores much of what the NCAA is allowed to do and what they've already done. They've specified, for example, with respect to postgraduate internships, they have to come from a conference or an institution. And left untouched by the injunction is the NCAA's right to prohibit boosters and all of those expenses untethered to education. So that's what my co-counsel and I are trying to argue here, is that Judge Wilkin really did tether the injury here to the remedy while not upsetting the balance, while remaining true. And she stated Board of Regents, she stated ample latitude, she stated the burdens, and frankly threw the NCAA a lifeline at step 2. And
so counsel, I'm sorry to interrupt you, but the cost of attendance covers the costs of attendance and is supposed to incorporate the various actual expenses that student athletes incur. So if the NCAA is sticking to a no pay for play model, isn't everything above that isn't tethered to protecting the athlete somehow pay for play, not tethered to a real expense?
Sure, Your Honor. There's a key flaw in this very line of reasoning, in my opinion. So this not one penny over cost of attendance just isn't true in practical terms. Right now, as the compensation framework stands, there are numerous ways that the NCAA allows students to get compensated for things like groceries and parking tickets and sure, well, excuse me, you mentioned not obviously related to the health of the players, but clothes as well. And they come from two funds that the NCAA allows schools to pull from to provide this money to athletes that are, frankly, they're spent on things unrelated to education. And so that's another thing that we argue here, is that while amateurism is no doubt a pro-competitive justification, in the sense that the way that the NCAA defines it is that players are not to be paid. And their vision, this is what preserves consumer demand. So at step 2, that's all fine and good, but it runs into two problems. One, there just isn't a coherent definition of amateurism. And 2, there's no workable principle provided by the NCAA on what it means to be paid.
So,
because, yes, go ahead, please.
I'm sorry, Counselor. So when you say no workable principle, I mean, this is complicated stuff, and I see that the Sherman Act and the NCAA have coexisted for 115 years. I also think it's a little bit odd, isn't it, that the findings of one trial judge will reshape the way this national institution works. I mean, isn't this just a matter that would be better left to Congress to work out a viable solution? I mean, clearly there's been a political change here, but shouldn't that be left to politics rather than a change of law?
Your Honor, I think you bring up a compelling institutional competency argument, but that shouldn't be at the expense of the injured parties here to vindicate their rights under the Sherman Act. And while we might be close to Congress coming to some sort of solution that makes everybody's lives a little easier, in my opinion, it shouldn't be at the expense of the student athletes here. And so just continuing a little more here, the NCAA has cried wolf a number of times. They've come into federal court and they've warned federal judges that certain things will spell the end of college sports as we know it. They said it in 1984 about the television rights and Board of Regents. They said it when it became an arms race for assistant coaches in Law v. NCAA in 1998. And they said it about, frankly, the most egregious pay-for-play that we've seen with NIL in 2015. But this crying wolf has been empty every time. They've been very wrong. In fact, consumer demand has only gone up. The NCAA is a astronomically revenue-producing machine. And so I urge this court to heed the history that the NCAA has here of using amateurism as a pretextual tool to cut their own expenses. Because even when you look at NIL stuff, they're okay with the NIL things, as long as they're not having to pay for it. It's from third parties. The working group said NIL all day, as long as it's from third parties. Ultimately here, we argue that the NCAA is most concerned about their own commercial interests and are not at all concerned with adhering to the academic tradition that Justice Stevens evinced and Board of Regents. And for all these reasons, we urge this court to affirm the Ninth Circuit and then the lower court's injunction. And thank you very much for your time.
Great. Thank you. And now, Grady or David, who's going to take your 3-minute rebuttal? Grady.
So, Your Honors, the NCAA would like to make it clear that it exists to promote the well-being and lifelong success of collegiate athletes and not for its own commercial benefit. And furthermore, the NCAA would like to make mention to the court that the court is not in a better position to define amateurism and preserve intercollegiate athletics. The NCAA is. The NCAA has been doing this for more than 100 years. What we've done in light of Board of Regents, in light of O'Bannon, is adjusted to the intrusion of the courts into our jurisdiction over what amateurism is. Despite the fact that Board of Regents clearly articulates that we should have jurisdiction over the definition of amateurism, and contrary to what opposing counsel stated, it is not dicta. What happened in Board of Regents is it was the TV deals were not related to amateurism. And so they did not apply an abbreviated review because this was for the commercial benefit of the NCAA, not to promote the welfare of the student athletes.
So, Council, you talk about the jurisdiction of the NCAA. Isn't it a valid concern of the courts that here we have the NCAA, which is effectively a monopolistic cartel, to put it in the harshest terms, that has total control over what benefits student athletes are going to receive, isn't? And it's getting a lot of money out of D1 football and basketball. Isn't that a valid judicial concern?
It is insofar as it answers the question of whether or not there's an agreement. But that's step one of the analysis here. And we concede that there is an anti-competitive restraint at issue in this case. What we contend is that what we're doing is providing a pro-competitive benefit through the provision of collegiate athletics for student athletes. And in doing so, we need to define amateurism because it's that precisely delineates between professional and intercollegiate athletics. And in doing so, we provide a new product. Providing a new product is pro-competitive. That's broadcast music. And so the issue is not that we're a trade association and that we govern the schools. The issue is that we're providing something new for the students. And with regards to the American Needle analysis that the opposing counsel gave, what we're asking for is not necessarily an exemption. We're just asking for jurisdiction over the definition of amateurism. So the analysis becomes, does the restriction relate to amateurism? And that's a case-by-case inquiry that antitrust desires to have in these cases. The antitrust is a case-by-case analysis as the economy evolves, but the NCAA needs to have the jurisdiction to be able to redefine amateurism and provide for certain narrowly tailored necessary expenses for student athletes. That's all we're providing. And that goes to the last point, is that our definition of amateurism is not incoherent because we seek to provide compensation for the expenses that the student athletes has as students and necessary. There are some nominal awards for exceptional academic achievement. And so with that, we'll rest our case.
Great job, everyone. That was fantastic. Thank you so much for the judges and the law students. That was a phenomenal hearing. Thank you so much. Any advice or any comments, feedback that the judges would like to give to our law students? Would be the perfect time.
I just want to let you all know that you did a phenomenal job, especially given the time frame, et cetera. You all did a wonderful job. So keep up the great work.
Yeah, I would echo Ebony there. You all did a fantastic job on your feet. You had a hot bench, if you will, and you did a really good job going with the flow, but also giving good responses. So kudos to all of you for a very good presentation.
And I'll third all that. I hadn't realized that the time was so short, and it's very difficult getting. This is a complicated case, and I know you didn't have to write briefs for it, but just absorbing the law and the decision below and all of that is very difficult. If there's time, I have more particular comments that I marked down. Should I offer them, Casey?
Yeah, we have
Okay.
plenty, and the next hearing is until 4:30. I mean.
Oh, okay. All right. So I'll do it the way I do at my home school when I judge a moot court. I mark down person by person. So Grady, I mean, very nice. I got the feeling you're a little bit nervous, but that comes with the territory. I know whenever I've argued, I'm nervous, and I write out my beginning just so that I have something to look at, because I know I'll be nervous. But I thought your manner was very nice, very, very well done. When you said at the beginning, preserving the opportunity to pursue a professional career, I thought maybe that's not the way you want to present it when the NCAA, you're emphasizing amateurism. I know, that there is the possibility that they'll have an amateur career, but I think you want to emphasize, the amateur, the student athlete aspect, which the NCAA actually does in its ads. I found reading the briefs, I found it very frustrating trying to figure out just what it was that this order requires them to do that they don't have to do. And I was trying to get an answer out of you, and I was trying to get precision, and that's something that you want to. That was a question to anticipate, to have it say the order requires us to do this and this and that, whether it's internships or whatever, but to come out with something concrete. Your rebuttal, I thought you were very effective there. I mean, I think you had in mind just what you wanted to do, and that was very good. David, very nice manner. You seemed, to enjoy it, which is a good thing. If you can seem to enjoy the whole process, that's very good. I thought you were responding. There are a few times where you said "they" about the NCAA, and it may be you may be revealing your long-standing feeling about the NCAA. I'm not sure, or you may be revealing your views on the substance of the case. But they are your client, and so you're gonna want to we, the NCAA, my client, whatever you want to associate with your client. I thought your ending might have wandered a little bit. I mean, you were going off into pro sports and the G League or something. I had a little bit of difficulty there. Ellie, very, very good again. I mean, you were, nice manner. You seemed comfortable, and it was very good. For my taste, I thought the introductions were a little long, and maybe that's because the time here is short, and I didn't want to interfere with the introductions. But in a moot court, particularly, you want to ask questions. In any argument, there should be. That's what the argument is about. Is not just a chance to speechify, because there are the briefs to have an interchange with the judges. I wasn't sure when you gave. I asked a question, and I'm having trouble remembering what it was, and you talked about pro competitiveness. Maybe it was responsive. It might have been. I wasn't certain. But very, very good, very professional presentation. Kit, likewise. I mean, you seem, seem kind of to be enjoying it, which is good. I thought the introduction was maybe longer than it needed to be. Some of your responses were interesting. One, you got a question. You said, "Well, the key flaw in that reasoning." Well, I don't know that you want to word it quite that way. You want to be careful, right? Because it might be that that's what the judge thinks, and it's a delicate matter, because you don't want to accept something you don't agree with that's going to hurt your client, but you don't want to say you idiot. I mean, it reminds me of the old Mae West line with she's testifying. Judge says, "Are you trying to show your contempt for this court?" And she says, "No, I'm doing my best to conceal it." So often that's what you got to do in an argument, is conceal your. I'm not saying you're feeling contemptuous, but I'm just saying you got to be careful of that. And it was interesting because on the other hand, there's another argument where you said, "Well, that's." I think I asked a question where you said that's. I mean, you anticipated the question about the institutional. I forget just how you rephrased it, but you were clearly ready for it, and you said that's compelling. I hear that. I think, okay, compelling. Compelling is strong words, and it's certainly an American constitutional word. That sounds like you got compelling on your side, you win. But those are picky. I thought your crying wolf was very effective. We've heard this before. We've heard it repeatedly, and that was very effectively. A personal thing with me, I seem to say this at every moot court I judge, is I would not bother with for the foregoing reasons, blah, 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 blah. I know somewhere out there in moot court world, you're told to end an argument that way. I think it's a little bit stultifying. I think finish with a bang, finish strong, and sit down. But anyway, as I said, excellent job, everybody, and congratulations. Hope you enjoyed it.
Great feedback. Thank you, Richard. That was. Thank you for the detail and everything. I mean, This is fantastic judges. I agree. I think we had a hot bench, and the students handled it phenomenally. Before I cut the segment and thank you guys one last time, I keep forgetting to mention NOCAP at the beginning. I'm too focused on the actual case at hand and not the business aspect. So NOCAP's mission is to give every athlete, regardless of school, sport, level, and background, equal access to the best technology, resources, and sponsorship opportunities to succeed in the name, image, likeness era. The NOCAP marketplace allows athletes, brands, and agencies to come together on one platform and execute meaningful partnerships. NCAA compliance rules are automated in the system for college athletes, NCAA, and schools in order to protect athletes and eliminate the compliance burden facing every institution. Patent pending. Thank you so much, everyone. Really appreciate everyone's time. The judges, students, amazing. Judges, if you can, please email me the score sheet. If you can, in the next 30 minutes, that'd be great. That we can tally it, get the results to the law students so they know if they're competing tomorrow and need to prepare tonight.
Hey, Casey, can I give a plug for a related matter too? Just a second. I'm so excited. Mitch Berman of Penn Law School and I have completed a book called The Jurisprudence of Sport: Sports and Games as Legal Systems. It's a textbook. It's going to be published by West. It's going to be available for courses this fall. We're hoping it's going to be taught at schools all over the country. So if you're interested in a course like that, speak to your, I know the UCLA people, third years, oh well, but speak to your associate deans, speak to whoever might decide to run the course. It's a whole lot of fun, but it's serious at the same time. So thank you for giving me the opportunity to plug it.
Happy to.
Appreciate it.
Thank you so much, you guys. And we will be in touch. Have a great day, everyone. Thank you, judges. Thank you, students.
Great work, everyone.
Great work. Good luck, everybody.
Amazing.
Thank you.
Welcome everyone back to NOCAP Sports Moot Court Madness. We have a phenomenal group of law students today from Notre Dame and UC Berkeley, and an amazing panel of judges that I can't wait to introduce. What I'm going to do is I'm going to go through introductions for our judges, and then I'm going to go ahead and pass on one by one so each law student can introduce themselves. Fantastic. So, hearing 4. Awesome. Our judges for hearing 4 include Maureen Weston, who is professor of law and director of the Entertainment Media and Sports Dispute Resolution Project at Pepperdine University School of Law. Her area of expertise is in sports law, arbitration, and dispute resolution. She is actively involved in working with students interested in sports and entertainment law and in promoting student engagement and experiential learning opportunities through national and international sports dispute resolution competitions. Weston received her JD from the University of Colorado and BA at the University of Denver. Thank you for joining us. Joshua Gordon is a Woodard Family Foundation Fellow, Senior Instructor of Sports Business and Law at the University of Oregon College of Business, where he teaches courses on the legal aspects of sports business, negotiation, global sports business strategy, sports branding and storytelling, law and sports business, sports mediation, and sports marketing. Outside of the University of Oregon, Mr. Gordon is an arbitrator for the Court of Arbitration of Sport in Lausanne, Switzerland, and an editorial board member of Law and Sport in the United Kingdom. He is also the founding practitioner at the Sports Conflict Institute. Mr. Gordon authored the Sports Playbook, Building Teams That Outperform Year After Year, and is currently writing a negotiation text titled Alignment is Power, Building Negotiation Excellence. Thank you for being here, Josh. Kelly Burton has an extensive background in athletics program development, international nonprofit operations, and legal consulting. Currently, Kelly is of counsel for the Allison Law Firm. Her practice includes transactions, business planning and governance, planning, zoning, construction litigation, intellectual property and estate, and legacy planning. She also advises organizations on cause marketing and community outreach efforts, particularly those involving sports and education. Kelly is a member of the Sports Lawyers Association, serving as the Nevada Outreach Captain and a member of the Philanthropy Committee. Thank you, Kelly. It's great to have all of you. I'm very excited for this competition. The law students, it is incredible to have everyone. Danielle, Jaden, Naya, Joshua, and Paige as an alternate for Notre Dame. It is fantastic to have everyone here. I'm going to go ahead and allow the law students to introduce themselves one by one. And why don't we start with Josh and Naya, and then we'll go on to Notre Dame. Josh, why don't you kick it off for us? Please give an introduction.
Yeah, good afternoon, everyone. My name is Joshua Morris. I'm a 2L at the University of California, Berkeley. I am interested in sports law, and this case really stood out to me. And additionally, I will be pursuing a transactional career this summer in New York City. I wanted to thank Casey and all of NOCAP Sports for putting on this competition. It should be a great experience. I'm looking forward to it.
Great.
Hi, my name is Naya Cord. I'm a 3L at UC Berkeley Law School. And as a 3L, I'm saying yes to a lot of things this year, and this is one of them. So I'm really happy to be here and entering this competition, and I look forward to telling you more about our case.
Fantastic. And Paige, why don't we start with you for Notre Dame? If we can.
Hi, my name is Paige Carey. I'm a 2L at Notre Dame Law School, and I'm very interested in this case. It's close to my background. I was a former student athlete, so I've really been following this case and excited to see where it goes. And once again, I know that other people said it as well, but thank you so much for putting this on. We're really excited.
Thank you. Jalen?
Good afternoon. Extremely grateful to be here. Jalen Amaker, 2L at Notre Dame Law School, former student athlete. So this is close to home. I've been following this throughout the year and over time. So again, thanks to everyone for putting this together and excited to compete against Cal Berkeley.
Great.
Hi, good afternoon, everyone. I am Danielle Lynn, 2L at Notre Dame Law School. I'm insanely interested in international sports law, so I'm really excited to have a bench that's really familiar with CAS and everything that happens outside of the US. This case is also near and dear to my heart. I'm not a former athlete, I'm a former sports reporter, and I've been following it as it's gotten through each stage of the case. Thank you, of course, to NOCAP Sports. Very excited to be here and compete.
Thank you. Fantastic. Well, I'm thrilled to have everyone. It's incredible that the law students were able to really digest information and be ready to argue it in moot court in such a short time. Please keep in mind, they did all of this in under 2 weeks, which is absolutely incredible while they are actually in classes at the same time. So all the credit really goes to you guys. So thank you very much. Now, before we get into the actual competition, I kick it off. I just want to give a little bit of background for anyone at home so they understand how this case has evolved to where it is at today. So just a little bit of background. The Alston case is different than O'Bannon, which was limited to name, image, likeness, because Alston was originally challenging the entire array of NCAA amateurism-based compensation limits. The student athletes originally alleged that the NCAA and 11 athletic conferences violated antitrust law by fixing the price of scholarships and other benefits, and Alston was arguing to create a free market. Now, the district court found for the athletes, holding that the NCAA must allow for certain types of academic benefits, such as computers, science equipment, musical instruments, and other tangible items, not including the cost of attendance, but related to academics. But why was the holding about education-related benefits when Alston was originally filed to challenge the amateurism model as a whole and attempt to create a free market? This tends to get lost on a lot of people, and that's why we're explaining it now. It actually takes me back to law school. You see, the district court was bound by the O'Bannon 2 decision, which prohibited an open market for the student-athlete services, and the remedy from the court was limited to education-related benefits. Basically, the O'Bannon 2 decision created an education limitation. So if Alston wanted a free market, then they would actually have to argue that O'Bannon 2 was wrongly decided at the remedies phase. You can see Justice Thomas's dissent in O'Bannon 2, but I'll paraphrase the justice. The majority looked at whether allowing athletes to be paid compensation unrelated to education is virtually as effective in preserving amateurism as not allowing the compensation. So the whole premise being preserving amateurism. Justice Thomas said the court should have looked at whether allowing athletes to be compensated for their name, image, likeness is virtually as effective in preserving popular demand for college sports in regards, and then vice versa, not allowing it. So essentially, should the antitrust analysis be about the concept of preserving amateurism or preserving consumer demand, with amateurism only being relevant as it relates to consumer demand? Since the majority in O'Bannon 2 looked at preserving amateurism, it provided a form of antitrust immunity to the NCAA because it foreclosed the free market argument and limited the judgment to education limitations. And that is where we find ourselves today with the Alston case. And now I'm excited to kick it back to our law students so we can have a moot court competition on what is actually at the Supreme Court now. Phenomenal. So who will be going first for, who is the petitioner?
We're the petitioner, Josh and I.
Fantastic. So UC Berkeley will be representing the NCAA in this matter. Great. And then Naya, Josh, who will be leading off for you guys?
I will.
Great. Okay. And then Naya, when you're ready, I will start the time when you go.
I am ready. Thank you. May it please the court, my name is Naya Cord, and I, along with my co-counsel Joshua Morris, represent the petitioner, the National Collegiate Athletic Association. I will address the first issue regarding judicial review, and I will yield my time to Mr. Morris to discuss the second issue on compensation restraint. With the court's permission, I would like to reserve 1 minute for rebuttal.
Granted.
Thank you. So the case we're hearing today is about preserving the underpinning of college athletics, amateurism. Deference to NCAA governance is warranted, and the Ninth Circuit erred by not using an abbreviated deferential review, but rather a detailed rule of reason analysis. In doing so, playing fast and loose with an issue that could essentially redefine college sports as we know it.
Counsel, could you tell us what the difference is between the quick look and the review that the Ninth Circuit provided in doing the balancing of the pro and anti-competitive, less restrictive alternatives? What is the difference and how is that significant?
Yes, Your Honor. So a quick review is basically essentially saying that on its face, the rule, the product is presumptively pro-competitive. And so in this case, the product is college sports. And on its face, it's pro-competitive because the distinction between college sports and professional sports is the fact that our student athletes or college students who are playing sports are not getting paid. And so what the deferential or abbreviated deferential review does is it says, well, this is on its face, this is a pro-competitive, this is presumably pro-competitive. And so we don't really need to go into a full rule of reason analysis. The member institutions of the NCAA got together, agreed on how they were going to compete against each other and the regulations that they were going to abide by, one of them being the restraint on compensation. And so in doing that, if that product is going to be non-existent, if we do the not if we do the rule of reason analysis, but if we look at it deeper and come to find that it is something that would not exist at all, then we're going to do the abbreviated deferential review.
Counsel, in Board of Regents and in Law versus NCAA, did the courts apply that deferential review, or did they apply the full rule of reason analysis?
Your Honor, can you repeat in what case you are asking about?
Board of Regents versus NCAA.
In Board of Regents versus NCAA, they applied the full rule of reason analysis. But I think that this case is closely tied to the Depp v. NCAA case. And in that case, they supported what we're saying and basically saying that NCAA rules that are presumptively pro-competitive don't need to go through this detailed rule of reason analysis and can just sort of have a twinkle of an eye look upon them.
Thank you.
Thank you. And so what we're saying here is that the NCAA's regulations, including those on athlete compensation, are necessary restraints. They're necessary because, one, they keep the distinction between college sports and professional sports. Two, they create opportunities for athletics, educational and athletic opportunities. And three, they maintain an orderly intercollegiate market. And so for these reasons that I just stated, the judgment that the Court of Appeals had should be reversed. To begin, the NCAA is a nonprofit association that imposes restraints on student athletes to keep its product of college sports different from professional sports. The only thing that differentiates college sports from professional sports is the fact that our college students are not getting paid for their athletic ability. And so for that distinction to exist, all of the member institutions had to agree on it. And Board of Regents teaches us that when a distinct product can exist only by horizontal agreement, restraints reasonably related to defying an association's pro-competitive product should be reviewed deferentially and upheld without a rule of reason analysis. This is because pro-competitive effects on amateurism are so strong that they should basically be presumed as a matter of law and outweigh any anti-competitive restraints.
Counsel, a question for you. Is amateurism really at the core of the differentiated product to differentiate from professional sports? There are many professional sports that have differentiation without that component. Can you speak to that a bit?
Yes, Your Honor. To answer your question, the distinction is indeed the fact that college sports or our college athletes are not getting paid. And that is the distinction between professional and college, is the fact that they are unpaid and professional athletes are paid.
But counsel, isn't it true that another distinction is that they are students, right? Student athletes, and they represent their schools. And I believe the lower court, the experts in the trial with Judge Wilkin that were proffered by the players didn't show that a difference in consumer demand necessarily if the athletes were paid.
Yes, Your Honor, it is true that our college students are also students and, of course, in class. But the main distinction between professional sports and college sports is the fact that the students aren't getting paid. There are some professional athletes who still attend classes online. So that is not the main distinction between professional sports and college sports. If you could repeat the second half of your question, I would really appreciate that so I can answer it.
No, please proceed. It was that they represent their schools as well, but you answered the question. Thank you.
Thank you. So, yes, okay, yeah. So while the abbreviated deferential review, we believe, is a standard that the lower court should have applied, the court also erred in its procedural review of the rule of reason analysis. The test assists courts in resolving the ultimate question under the Sherman Act of whether it benefits consumers. And the test is a burden shifting framework that consists of 3 distinct steps, and we're going to focus on 2 of them. The first step, at step 2, the NCAA demonstrated that there's a net pro-competitive effect because the rules, 1, widen the options available to consumers and athletes, 2, create educational and athletic opportunities because the money that the schools make from the athletic programs are then getting put back into the schools, and thereby they're able to recruit and draw in new students to their institutions. The Ninth Circuit wrongly required that the NCAA prove that each type of challenged rule has pro-competitive benefits rather than a challenged rule collectively having such benefits. At step 3, the plaintiff could not provide a substantially less restrictive yet equally effective alternative that would preserve amateurism because it simply doesn't exist. The court erred in finding that the paid post-eligibility scholarships, the cash awards, tangible in-kind benefits was a less restrictive alternative that would maintain the true distinction between college and professional sports. All these alternatives are compensation for student athletes' play and would actually negatively impact the educational experience of many of them. For instance, some schools would be forced to reallocate resources, and that would reduce maybe the number of sports teams or scholarships that they're able to provide, or even if students are being able to achieve their college education at all. I would like to yield the rest of my time to my co-counsel, Mr. Morris, to discuss compensation restraints.
Thank you, counsel.
Thank you, Ms. Cord. May it please the court. Good afternoon. My name is Joshua Morris, and I'm the co-counsel representing the NCAA and will be addressing the second question presented before the court. Even if the rule of reason analysis is the correct procedural analysis to use here, the NCAA rules do not constitute an antitrust violation because these rules are necessary to preserve amateur intercollegiate athletics, and the pro-competitive effects far outweigh any anti-competitive effects associated with them. This court expressed in broadcast music that joint ventures and other collaborative agreements are not unlawful when they necessarily must reach an agreement to produce the product. That is exactly the circumstances here. And these rules are necessary for 2 main reasons that I will elaborate on. First, the NCAA's rules provide a clear line of demarcation between amateur intercollegiate athletes and professional athletes. This court explicitly outlined in Board of Regents decision the defining characteristic of the NCAA's product of intercollegiate athletics by stating that student
Mr.
athletes—
Morris, excuse me for interrupting you. You're saying that that this is necessary, but there's evidence that schools are buying insurance policies and doing things that are above and beyond what would be considered the cost of the admissions. Could you speak to that? That sort of seems to me like perhaps it cracked a door open.
No, Your Honor, we do not believe that cracked a door open. There are explicit exemptions that are outlined in Article 12 of the NCAA bylaws that permit certain forms of payment for these athletes. However, they are precisely calculated, and these payment forms are not just thrown there by blindly. We precisely calculated what type of payments would not affect the overall amateurism. These are related to educational benefits and are capped, unlike the lower court's ruling that is permitting uncapped education-related benefits.
Thank you.
In the Board of Regents, the defining characteristic of the NCAA product that this court outlined was stating that student athletes must not be paid, must attend class, and the like. Pay is clearly the point of demarcation here, not unlimited cash compensation, which the lower court incorrectly stated. This court would not have used such strong language defining the characteristics of intercollegiate athletics if pay was not the clear point of demarcation between professional athletics and collegiate athletics. The lower court ruling allowing unlimited paid internships and expenses related to education benefits redefined the NCAA's product altogether by eliminating the essential function of amateurism, that intercollegiate athletes do not get paid. How can unlimited pay for post-eligibility internships, which is one of the consequences of the lower court's injunction, not be viewed as unlimited cash compensation? Institutions within the NCAA are able to lure athletes into their schools by guaranteeing a post-eligibility internship that pays unlimited sums of money. That is in a direct contradiction of the lower court's justification of what separates professional athletes and intercollegiate athletes. If these athletes are able to receive unlimited amounts of pay insofar as the internship relates to education, that is the same thing as receiving unlimited pay. Additionally, this standard is extremely easy to meet. The second main reason is that—
Could you please clarify what relief you would like from this court, or the consequences of us granting your motion, the relief that you're seeking to reverse the Ninth Circuit? Then what would be the status of college sports?
We would like this court to reverse the Ninth Circuit's decision so that the NCAA continues to have the ample latitude that was granted to it through the Board of Regents' decision through this court. These agreements and these horizontal agreements, quote unquote, from the petitioners or from the respondents are necessary in order to preserve amateurism and should be deferred to the NCAA and its member institutions' agreements. Just as BMI stated, that in order for the product to exist, if these restraints are necessary, then they should be deferred to the member organizations.
Thank you.
In conclusion, the NCAA must be afforded ample latitude as stated by this court and the Board of Regents, because the pro-competitive effects on consumers clearly outweigh any anti-competitive characteristics associated with the NCAA rules. The NCAA rules provide a separate market that is completely distinct from professional athletics as we know it. Additionally, more educational and athletic opportunities are provided to the 22 other collegiate athletics that are part of the NCAA's concept, in which nearly 500,000 participants engage in. If the lower court's injunction is allowed to persist, resources will be devoted away from these other sports, thereby constricting the overall consumer output and the overall output of opportunities for these athletes to engage. So, as a result, we respectfully ask for the judgment of the Court of Appeals to be reversed. Thank you.
And for Notre Dame, who is speaking first? Is it Jalen or Danielle going first?
Danielle.
Yeah.
Then Paige is also arguing point 2.
Oh, okay. Jalen, are you the alternate?
Yeah, I'm here for support.
Yeah.
Let's start this.
Okay. And Danielle, whenever you're ready, I will start the timer on your go.
Okay, sounds good. Thank you. Good afternoon, and may it please the court. My name is Danielle Lynn, and I, alongside my co-counsel, Paige Carey, represent Sean Alston and the student athletes in this case. Ms. Carey and I will split our time evenly. The Ninth Circuit was correct in reviewing the case under a detailed rule of reason analysis for 2 reasons. First, the NCAA's argument relies on dicta that is contrary to this court's holding as a matter of law. Second, the landscape of the NCAA has materially changed since the cases that the petitioners rely on were decided. To my first point, the petitioners' argument that they should be afforded a deferential review is mistakenly interpreted from non-binding language of this court. The petitioners argue that language in Board of Regents allows NCAA regulatory controls to be considered pro-competitive. That language is dicta. Board of Regents says that NCAA rules may be considered pro-competitive, but those restraints must be reasonably related to defining the NCAA's product. This court qualified the scope of that language in the opinion. It said that the regulatory controls they were referring to were rules defining the conditions of the contest and the eligibility of the players. The regulations at issue in this case are about an anti-competitive academic restriction. They do not fall within the scope of the language that the petitioners rely on. Here, the NCAA is asking you to expand the scope of the court's reasoning by likening educational benefits to eligibility. The challenge rules at issue today are not based on any desire to maintain the integrity of college athletics. The district court found and the Ninth Circuit affirmed that the challenge rules were adopted without consulting demand studies or the market at large. Instead, these rules were adopted based on a cost-benefit analysis. They do not define conditions of the contest or the eligibility of the participants. Instead, they cap academic-related benefits at a cost-saving initiative. This case clearly falls outside of the purview of the language in Board of Regents. Further, in Board of Regents, the case itself, it was held as a matter of law that the NCAA rules are subject to a rule of reason analysis. And while that case dealt with a different issue, looking at joint restraints and TV licensing agreements, there the court also employed a rule of reason analysis. To my second point, the landscape of the NCAA has materially changed since the cases that the petitioners rely on were decided. It is established practice, and the Ninth Circuit noted in the opinion below, that antitrust decisions are particularly fact-bound. Each case arising under the Sherman Act must be determined upon the facts on the record before the court.
Counsel, I'm sorry to interrupt. And this might relate to your partner's argument, and if so, just let me know. But the NCAA is arguing that even if it's correct that the rule of reason analysis applies, that the lower courts have applied this not just less restrictive, but least restrictive alternative. And they said, we're never going to stop getting sued because they're always going to find some least restrictive alternative to whatever the NCAA is doing. How do you respond to that argument?
Well, respectfully, Your Honor, I would disagree with that. The courts did not open the floodgates of litigation on the NCAA. Instead, what they were saying was what was established in Board of Regents, first as the Ninth Circuit correctly identified, was dicta. But aside from that, what they were saying was this this that we're challenging before the court today, the academic restraints, they do not advance a pro-competitive end. Any pro-competitive end that the NCAA seeks to regulate, the courts can, and they are allowed to defer to the pro-competitive end. Here, that is not the case. So this is a very narrow holding, and it specifically applies only in the academic-related context. The NCAA is asking the court. Yep. Excuse me. Nope.
Go ahead. Sorry.
The NCAA is asking the court to apply analysis from a context wholly different from the issue before the court today. At the time Board of Regents was decided, the NCAA did not allow student athletes to be paid. That was the clear line of demarcation. Since then, however, the NCAA has completely changed its position, on compensation. And as a result, that amateurism definition shifted. The Ninth Circuit found that the compensation rules have been riddled with exceptions from the NCAA. The district court established that without losing eligibility, the NCAA permits student athletes to receive athletic performance awards. That is a monetary value solely off of athletic performance. The NCAA also permits disbursements from the SAF funds that can go above the cost of attendance. They permit cash stipends to cover costs that the athlete can use at their discretion. In addition, medical insurance and medical care for athletic-related injuries that they allow to extend for 2 years after an athlete has left the academic institution. The student athletes are allowed unlimited meals and snacks. They also can get reimbursements for their significant others and children to attend certain championship NCAA events. Finally, the district court concluded that student athletes are allowed a $30 per diem for traveling and practice during championship events.
Counsel, if I may, how do you see the NIL laws that are pending in different states at the moment? How do they relate to some of your argument here today?
Sure. Well, again, the case before the court today, Your Honor, is specifically considering the academic cap on the benefits allowed. Name, image, and likeness does go purely towards the athletic compensation route. So it is distinguishable there. However, I do think the NCAA, if this name, image, and likeness legislation does go through and there are no successful challenges to it, will need to go beyond reinterpreting how they structure based on this case and the outcome of this case, but also in their athletic related benefits as well.
Thank you.
So, Ms. Lynn, you've given us a laundry list of the educational benefits that you have received. What else is it above and beyond that's not there?
Can you repeat the question? I'm sorry, Your Honor.
You had given us a laundry list of the educational benefits that the NCAA was indeed allowing for student athletes. And what else is it that you'd like?
What else is it that I'd like?
Beyond the list of, you said $30 a day, tickets to the championships, those kind of things. What else additionally are you looking for?
Oh, okay, sure. So my point in bringing up those rewards that the NCAA allows is to point out that that's completely related to their athletic ability and nothing to do with their academic achievements, which is what we are fighting for. So what the respondents are asking for from the court is that if the NCAA is allowed to go beyond their scope of amateurism and the no pay for play that they posited 37 years ago in Board of Regents, then it must be the case that the cap on academic related, which are fixed costs, can surely go up as well. The NCAA's own actions are inconsistent with the Board of Regents language that they are asking you to rely on. The courts below properly concluded that the compensation landscape had meaningfully changed, and they employed a detailed rule of reason analysis to determine the competitiveness of the restraints. Opinions must be read in light of their facts, and the court below did so properly. For those reasons, The respondents are asking the court to affirm the Ninth Circuit decision and that it was correct in using a detailed rule of reason analysis. Thank you, and I will reserve the balance of my time for my co-counsel, Paige Carey.
Thank you.
Good afternoon, Your Honors. I, Paige Carey, along with my co-counsel, Danielle Lynn, represent the respondent, Sean Alston, the Division I basketball players, and FBS football players. Your Honors, we respectfully ask you to find that the Ninth Circuit was correct in its reasoning that the NCAA's eligibility rules restricting the compensation of student athletes violates federal antitrust laws for the following 3 reasons. First, the NCAA is not a single joint venture entity exempt from Section 1 of the Sherman Act, as they claim. Second, the rules at issue control costs without a demand-related reason. And third, the less restrictive alternative identified left both the NCAA and individual conferences with the necessary ample latitude to determine what qualifies as an educational-related benefit. With respect to my first
point, sorry, to your first point about whether the NCAA is considered a joint venture, how does the American Needle test apply in this case? Is it true that these are like eligibility rules and these might be essential to how the NCAA operates so that they're exempt from antitrust scrutiny?
Your Honor, the American Needle case tells us that the mere fact that firms operate jointly in some sense does not mean that they are immune. And the rationale behind that was that members of any cartel could simply insist that their cooperation is necessary to produce the cartel product and compete with other products. The NFL is a wholly owned subsidiary. So if anyone was to receive an antitrust exemption, it would be them. The NCAA already has a wide variation among conferences and schools in Division I in terms of the compensation they permit and their student athletes receive. And professional sports, being more integrated than the NCAA, receive ordinary Section 1 treatment. Therefore, there is no reason the NCAA should not also receive Section 1 ordinary treatment. And Congress is actually the entity that should give the antitrust exemption. With respect to my second point, the NCAA controls costs through their rules without a reason tied to demand. Amateurism is only a pro-competitive justification to the extent that it improves demand. And the courts below found there is no evidence that the NCAA bylaws limiting compensation are enacted based on an analysis of consumer demand. The challenged rules were instead based on discussions to control costs. In Law versus National Collegiate Athletic Association, the court tells us that an agreement among competitors to control costs constitutes an unreasonable restraint of trade and not a pro-competitive justification. In Board of Regents, the case tells us that the NCAA could not limit broadcasting games to protect live attendance on the assumption that the product itself is insufficiently attractive to consumers, because this would be inconsistent with the basic policy of the Sherman Antitrust Act. The NCAA relies on an ever-changing definition of amateurism. We are not clearly told what it means. O'Bannon recognized that student athletes are the one group of students on campus being treated differently than everyone else. And there's lots of argument about the definition of amateurism, but at the core of this argument, really the definition of amateurism does not matter when the defendant can offer no explanation for why the limits are necessary for the preservation of consumer demand. In O'Bannon,
Ms. Carey, excuse me. So are you claiming that the NCAA shouldn't be allowed to institute any rules on amateurism?
Your Honor, we take the stance that the definition of amateurism is not clear. And this has also been shown in O'Bannon, and it has been shown in the Ninth Circuit where Judge Wilkins said that the definition was incoherent. And so amateurism can have pro-competitive effects, and this court here held that amateurism had a pro-competitive effect when it was held against education-related benefits. However, to the extent that the NCAA is arguing amateurism controls demand, that has not been proven. After O'Bannon, which permitted education-related benefits, the NCAA had the rules permitting benefits not tied to education, and there was no change in demand to be found. And this natural experiment proves that amateurism is not relevant in demand in those cases. And O'Bannon also tells us that education-related compensation is consistent with demand. NCAA's president, Mark Emmer, also says the same. He states that having conferences compete over who can provide the best educational experiences is an inherently good thing. The NCAA already allows insurance policies, traveling expenses, and other benefits that are totally irrelevant to education. And these rules have not been tailored since O'Bannon to be related to education. Last, the less restrictive alternative left both the NCAA and individual conferences with ample latitude to determine what qualifies as an education-related benefit. The injunction is based on whatever the NCAA itself already allows for athletic performance. Therefore, it is the NCAA and not the court that determines what level of payment would harm demand. The NCAA is also able to propose its own definition for the term related to education, and it allows each conference to impose whatever education-related compensation cap it chooses. Unlike the NCAA, individual conferences do, Your Honor, may I briefly conclude? Do not have the market power and thus survive a rule of reason challenge. For these reasons, we respectfully request the Supreme Court affirm the Ninth Circuit decision. Thank you.
Thank you.
And Josh, Naya, who is going to handle the 1 minute rebuttal? Okay. And whenever you start, Josh, I will start the time.
The respondents are contesting that the Board of Regents opinion that we cited is dicta. If the court's opinion is classified as dicta, then the less restrictive alternative test that the Ninth Circuit uses in the third step of the rule of reason analysis must also be viewed as dicta. The less restrictive alternative test has never been explicitly approved by this court in a horizontal restraint analyses. In fact, the only mention of it occurred in Ohio versus American Express, in which it was only mentioned and not adopted by this court. Additionally, the less restrictive alternative test has been affirmatively rejected in a court case involving vertical restraints, which is Continental TV versus GT Sylvania. Lastly, we are not asking the court to do Congress's job by giving us an exemption. We're asking the court to reverse the lower court's ruling on the grounds that the court simply erred in how it reviewed the case, and that the consequences of upholding it means that the district courts will continuously have jurisdiction over this matter and leave it at the hands of one judge in California. Thank you.
Fantastic job, everyone. That was a fantastic hearing, and everyone should be proud. As a great job. Thank you to the judges and to our participants. Did an amazing job, especially considering the time constraints and how we fit this into within 2 weeks. Judges, I'd love to give you guys an opportunity if you'd like to give feedback or any advice to our participants.
I thought you guys were great. I'm glad I didn't compete against you guys when I was in law school. I'm just going to say that right now. So congratulations, and I do wish you guys all the best in your next chapters.
So impressed by your ability to handle tough questions and then resume your line of thought and to incorporate some of the questioning back into where you were at that point. Really excellent job.
Yeah, I agree. You were all very well poised and handled our questions. And so very good overall. I just wondered from the NCAA, did you want to hammer more the pro-competitive justifications for the current regime? Because that quick look, I know that's what they're arguing, but it seems like even it seems more persuasive that the rule of reason applies, but then I think it was Naya, you were talking about the threat to every other sport. I don't know how that plays out, but there's the competitive balance concern is something that you might want to talk about. And and I just taught the baseball exemption case, which is totally dicta and totally gives MLB this blanket exemption from antitrust laws. And I just wonder if Board of Regents could be as ridiculous as federal baseball is, and say it's up to Congress, but we created the exemption. That's a theory. But the NCAA isn't making these arguments that you guys made stronger arguments than some that I've seen. And the players have the remedy. So Casey, bringing that outline at the beginning, because it's a very confusing case on who's the petitioner and who's the respondent. Like, what do they want? Because it seems like the players aren't really satisfied with this education related, because there's Jeff Kessler's going to be there for the next case, attacking even that's a limit too. And what's the justification for that? So it's a fascinating case, and I'm so excited for you all for taking this on. Great job.
Absolutely.
Fantastic. Maureen, you bring up a great point, which I'd love to just kind of talk about offhand, but next week on Friday, we're going to be hosting, we haven't announced it yet, but we're going to be hosting a expert panel. And one of the panelists actually wrote an amicus brief for this case. And it was an amicus brief on behalf of minor league baseball. And it'll be a very interesting panel because of that. I think what you just said is so critical. This could end up in the same light and really get an antitrust exemption through the courts and end up like MLB. So hopefully not, but you bring
it's
up
wild.
It is,
especially with this sort of all or nothing that it seems to be on both sides. That I think that's where it gets really interesting in my brain when I think about it. It's all or nothing.
Yeah, unfortunately, right now it seems like the student athletes have a lot to lose because if the NCAA gets an antitrust exemption, that's a huge deal. Whereas really they don't have much to gain because it's limited to the educational benefits and just reaffirming the Ninth Circuit rather than what they originally were after when they started this case in 2014. So 7 years later, and they can't even go after what they originally wanted to. But it is what it is, and we don't have control over that. So thank you so much, everyone. This is an amazing event. I'm so glad to have you guys all participating. For the judges, I would just ask that take some time in the next 20, 30 minutes, if you could provide the score sheet back to me so I can let the teams know. And that way, whoever it is, someone's got to be preparing for tomorrow. And actually, before I let everyone go, I keep forgetting to do this. I should be doing it at the beginning, but I'm more focused on the legal aspects of the business. But let me go ahead and explain what NOCAP is, just in a quick little 2 sentences. NOCAP's mission is to give every athlete, regardless of school, sport, level, and background, equal access to the best technology, resources, and sponsorship opportunities to succeed in the name, image, likeness era. The NOCAP marketplace allows for athletes, brands, and agencies to come together on one platform and execute meaningful partnerships. NCAA compliance rules are automated in the system for college athletes, NCAA, and schools in order to protect athletes and eliminate the compliance burden facing every institution. That is a quick snippet. Thank you guys so much. Judges, again, please send me the score sheets. And Notre Dame, Berkeley, you guys did amazing.
Thank you.
Really
Nice job, advocates. Congratulations.
Thank you so much.
Thank you. Thank you. Nice to meet you, Casey. Good to see you, Josh.
You too.